proceedings. Honorable Dr. Otiende Amolo, Honorable George Murugara, Honorable Samuel Chepkonga, Honorable John Makali, and Honorable Zamzam Mohammed.
I'm informed that all the parties are now settled, ready for this hearing. I will therefore allow the clerk to call the first order. Senator Eddy and Senator Siango, why are you exchanging seats? Proceed, clerk.
Order number 2, reading of the charges on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
Honorable Senators, ladies and gentlemen, having dispensed with the pre-hearing meeting of the Senators, which was a closed session, it is now time to commence the proceedings on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. You will recall that by a letter reference number NA/DLP/TBO/MTS/2024 into brackets 025, dated the 8th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate that at a sitting of the National Assembly held on Tuesday, the 8th of October 2024, pursuant to Article 145(2), as read with Article 150 of the Constitution, the National Assembly approved a motion for the removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. The Speaker of the National Assembly forwarded the following documents to the Senate, being the record of proceedings of the National Assembly and the evidence adduced in support of the impeachment motion. 1, a copy of the notice of special motion and an affidavit of the Honorable Ekomas Mwengi Mutuse, OGW MP, dated 26th of September 2024 and received on the 27th of September 2024, running from page 40 to 42. 2, electronic evidence relating to the special motion contained in a flash disk. 3, order papers for 1st of October 2024, communication from the Chair number 046 of 2024, issued on Tuesday, the 1st of October 2024, communication from the Chair number 047 of 2024, issued on Tuesday, the 1st of October 2024. Certified Hansard and votes and proceedings for the 1st of October 2024, communication from the Chair number 048 of 2024, issued on the 2nd of October 2024. Letters of appointment of advocates for A, Swanya and Company Advocates for His Excellency the Deputy President, B, Dunstan Omari Advocates for Morani Manufacturers Limited. Letter to His Excellency the Deputy President, forwarding the notice of motion, affidavit of service on His Excellency the Deputy President, order paper for the 2nd of October 2024, certified Hansard and votes and proceedings for the 2nd of October 2024, public participation advertisement of the 2nd of October 2024, being the Daily Nation newspaper, Standard newspaper, and Star newspaper. Public participation advertisement of the 3rd of October 2024, being the Daily Nation newspaper, Standard newspaper, Star newspaper, and Taifa Leo. Public views, template, English and Kiswahili, memo to constituency/county office managers, dated the 4th of October 2024. Public participation advertisement of 4th of October 2024, being Daily Nation newspaper, Standard newspaper, and Star newspaper. Order issued by the High Court, sitting at Kerugoya on Friday, the 4th of October 2024, press statement by the Clerk of the National Assembly on the extension of public participation issued on the 4th of October 2024. This communication is long, and bearing the situation of Senator Gloria Oroba, I will allow her to take her seat. Praise statement by the Clerk of the National Assembly on the extension of public participation issued on the 4th of October 2024. Public participation advertisement of the 5th of October 2024 being standard Saturday Nation newspaper and standard newspaper. Public participation report tabled on the 8th of October 2024. Response to the notice of special motion from His Excellency the Deputy President received on the 8th of October 2024 at 4 p.m. Electronic evidence by His Excellency the Deputy President relating to the special motion contained in a flash disk. Order paper for Tuesday the 8th of October 2024. Communication from the Chair, number 049 of 2024, issued on Tuesday the 8th of October 2024, and certified Hansard and votes and proceedings for the 8th of October 2024. Now, Honorable Senators, pursuant to Article 145, subsection 3A of the Constitution, and Standing Order 78-1 of the Senate, at the sitting of the Senate held on Wednesday, the 9th of October 2024, the charges against His Excellency the Deputy President, as contained in the motion of impeachment by the National Assembly, were read out to the assembled Senate. Honorable Senators, at this juncture, allow me to remind you of the mandate of the Senate in relation to the proposed removal from office by impeachment of the Deputy President as provided for under Articles 150 and 145 of the Constitution, as read together with Standing Order 78 of the Senate. In particular, Article 150 of the Constitution states as follows: the Deputy President may be removed from office, A, on the ground of physical or mental incapacity to perform the functions of the office, or B, on impeachment on the ground of a gross violation of a provision of this Constitution or any other law, and 2, where there are serious reasons to believe that the Deputy President has committed a crime under national or international law, or 3, for gross misconduct. 2, the provisions of Articles 144 and 145 relating to the removal of the President shall apply with the necessary modifications to the removal of the Deputy President. Now, Article 145 of the Constitution, Standing Order 78, Part 1 of the second schedule of the Standing Orders of the Senate, provide for the procedure to be followed in the hearing and determination of the proposed removal from office by impeachment of the Deputy President. Specifically, Article 145.3 of the Constitution and Standing Order 78.1 of the Senate provide that the Senate may, by resolution, appoint a special committee comprising 11 of its members to investigate the matter. Honorable Senators will recall that at a sitting of the Senate held on Wednesday, the 9th of October 2024, the motion for establishment of special committee was deemed to have been withdrawn pursuant to Standing Order 70. This therefore paved the way for the investigation on the proposed removal from office by impeachment of His Excellency the Deputy President of the Republic of Kenya to be held in plenary. Honorable Senators, ladies and gentlemen, by way of status update, pursuant to Rules 4A, Senator Karen Nyamo, attentive please. By way of status update, pursuant to Rules 4A and 6 of the Rules of Procedure, when considering the proposed removal of the Deputy President in plenary, the Senate invited the Deputy President to appear and be represented before the Senate during its investigation. The Senate further invited the Deputy President, if he so chooses, to appear before the Senate to file an answer to the charges with the Office of the Clerk of the Senate by 5 p.m. on Monday, 14th of October 2024, setting out the following. 1, the Deputy President responds to the particulars of the allegations. 2, the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. 3, the names and addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate, and lastly, any other evidence to be relied on. Pursuant to Rules 4B and 7 of the Rules of Procedure, when considering the proposed removal of the Deputy President in plenary, the Senate notified the National Assembly of the date for the commencement of the investigation and invited the National Assembly to designate members of the National Assembly who shall appear and represent the National Assembly before the Senate during the investigation. The National Assembly was further invited, if it so chooses, to appear before the Senate to file with the Office of the Clerk of the Senate by 5 p.m. on Monday, 14th of October 2024, setting out documentation of the following. 1. Designating members of the National Assembly, if any, who shall attend and represent the National Assembly in the proceeding before the Senate. 2. Indicating the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. 3. Indicating the names and addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate. And lastly, specifying any other evidence to be relied on. Now, Honorable Senators, ladies and gentlemen, on 14th of October 2024, the Office of the Clerk of the Senate received a response reference number SW/PET/153/VOEN/01/2024 and dated the 14th of October 2024 to the invitation to appear issued to the Deputy President from a senior company advocate who indicated that His Excellency the Deputy President had appointed the firm to represent him in the proceeding before the Senate, and that the Deputy President would also appear in person and by advocates. The letter also indicated the list of counsel representing His Excellency the Deputy President and the list of witnesses for the Deputy President. Similarly, on 14th of October 2024, the Office of the Clerk of the Senate received a response reference number NA/CAN/CO/2024 and dated 14th of October 2024 to the invitation to appear issued to the National Assembly from the Clerk of the National Assembly indicating that Mrs. G&A Advocates LLP had been appointed to represent the National Assembly and that the National Assembly would appear in person and by advocates. The letter also indicated the members of the National Assembly representing the National Assembly in these proceedings and the witnesses for the National Assembly. Pursuant to Rule 8 of the Rules of Procedure, when considering the proposed removal from office of the Deputy President in plenary, on Monday, 14th of October 2024, the Clerk of the Senate furnished each party with the documentation filed by the other party in accordance with Rule 6 and 7 of the Rules of Procedure. Honorable Senators, ladies and gentlemen, the hearing program, which has been appended to today's order paper, details the various activities in the hearing and determination of the matter and the time allocated for each activity. It will be crucial that all parties comply with the time allocated. I will repeat, it will be crucial that all parties comply with the time allocated. The parties will be notified of the balance of time on each activity through the clerks at the table. In summary, the program states that after we have dispensed with the preliminary matters today, Wednesday, 16th of October 2024, the charges against the Deputy President, as submitted by the National Assembly, shall be read. Thereafter, His Excellency the Deputy President will be given an opportunity to take a plea on the charges. This will be followed by an opening statement by the National Assembly and the Deputy President. After the conclusion of the opening statements, the presentation of the case of the National Assembly shall commence. The National Assembly will have a maximum of 3 hours for presentation of the case and re-examination, while the Deputy President will be allocated 2 hours for cross-examination of witnesses after presentation of the case by the National Assembly. Honorable Senators will be given an opportunity to ask questions or seek clarification from the National Assembly. This should take us up to the end of today's sitting. At the sitting scheduled for tomorrow, Thursday, the 17th of October 2024, His Excellency the Deputy President will present his case before the Senate. The Deputy President will have a maximum of 3 hours for presentation of the case and re-examination, while the National Assembly will be allowed 2 hours for cross-examination of witnesses. Honorable Senators will also be given an opportunity to ask questions or seek clarifications from the Deputy President, following which the closing statements by the parties will be made for a period not exceeding 1 hour each. As provided for under Rule 27 of the Rules of Procedure for removal of Deputy President by impeachment, after the closing statements have been made, the hearing shall conclude and the Senate shall proceed into camera session to deliberate on the issues raised. The Senate shall thereafter proceed to debate a special motion prior to voting on each of the charges. At this stage, a supplementary order paper will be issued to facilitate this debate. In accordance with Article 145(7) of the Constitution and Standing Order 788 of the Senate, the voting shall be by all senators. The Deputy President shall cease to hold office if at least 2/3 of all senators vote to uphold any of the impeachment charges. If, however, the vote in the Senate fails to result in the removal of the Deputy President, the Speaker of the Senate shall notify the Speaker of the National Assembly accordingly. Honorable Senators, I now invite Counsel for the National Assembly to introduce the legal team of the National Assembly and the members representing the National Assembly by stating the full name and designation of each person. You may proceed, Counsel.
Mr. Speaker, sir, for the National Assembly, the legal representation is as follows. The Honorable James Orengo, Senior Counsel, leading the team. Mr. Paul Nyamodi, Legal Counsel. Myself, Eric Gumbo, Legal Counsel. Dr. Mudomi Viankolu, Legal Counsel. Mr. Moses Kipkogei, Legal Counsel. Mr. Peter Wanyama, Legal Counsel. Mr. Ken Meli, Legal Counsel. And Mr. Mwangi Kangu, Legal Counsel. Mr. Speaker, sir, this team is further assisted by a team of our younger colleagues, Mr. Alex Bayer, Legal Counsel. Mr. Elias Ouma, Legal Counsel. Mr. Eric Muriuki, Legal Counsel. Mr. Boniface Mawira, Legal Counsel. And Ms. Joanne Jeruto, Legal Counsel. From the National Assembly, we have the Honorable Otiende Amolo, Senior Counsel. We have the Honorable George Gitonga Murugara. We have the Honorable Samuel Chepkonga. We have the Honorable John Makali. And we also have the Honorable Zamzam Mohammed. I submit, Mr. Speaker, sir.
I similarly now invite Counsel for His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya, to introduce the legal team representing His Excellency the Deputy President by stating the full name and designation of each person. Counsel, you may proceed.
Mheshimiwa Speaker, Honorable Senators, the legal team representing His Excellency the Deputy President of the Republic of Kenya, who is present in this august house, are as follows. Myself, Paul Muite, Elisha Ongoya, Tom Macharia, Soanya Victor Ogeto, Ndego Wanjiro, John Jomo, Faith Waigwa, Amos Kisilu, George Wandati, George Sakiba, Andrew Muge, Eric Naibei, Mrs. Julia Omwamba, and Mr. Willis Echeza. Mheshimiwa Speaker, we will be raising an issue about one of the members of the legal team read out this morning as representing the National Assembly. I thank you, and I thank honorable members.
Honorable Senators, ladies and gentlemen, on behalf of the Senate, I welcome the National Assembly and its team, His Excellency Rigathi Gachagua, AGS, the Deputy President of the Republic of Kenya, and his team, members of the public and the media, to the Senate and to these proceedings. Now, as you are aware, Article 118 of the Constitution mandates Parliament to conduct its business in an open manner, and that its sittings and those of its committees shall be open to the public. The hearing of the proposed removal from office of the Deputy President pursuant to Article 145 of the Constitution, Standing Order 78 and the second schedule to the standing orders of the Senate is a matter that has generated immense public interest. The Senate, in this particular hearing, has facilitated members of the public who are interested in the proceeding to access its galleries. However, I draw the attention of the members of public who are seated in the galleries to Rule 28 of the Speaker's rules, which state as follows: visitors in the galleries shall remain seated, shall not applaud, comment audibly, make signs, eat, sleep, read books, newspapers, or other material except the order paper for the day, or create any disturbance. I request the members of public to observe the aforesaid rule. Any member of the public who contravenes the Speaker's rule will be inviting stern action against them, which includes expulsion from the precincts of Parliament. The office of the Clerk of the Senate is directed to ensure compliance with the Speaker's rules. Honorable Senators, ladies and gentlemen, finally, I now invite the Clerk to read the particulars of the allegations against His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. Clerk, you may proceed.
Mr. Speaker, sir, my name is Wanjiru, and perhaps before we proceed to the next session, my learned senior counsel, Paul Moite, did raise an issue that we have an objection in terms of the appearances of legal counsel appearing for the National Assembly. Mr. Speaker, sir, our objection is in line with the conduct of this House, and the records bears as witness that we also have, we'll also be relying on an authority in our objection. Mr. Speaker, sir, we are raising an objection to the appearance of my senior advocate, legal counsel, James Orengo, to represent the National Assembly in these proceedings. And this is the basis of our objection briefly, that my learned friend, senior James Orengo, is a full-time serving state officer as per Article 260 of the Constitution, as read together with Section 26, subsection 2 of the Leadership and Integrity Act, which bars a full-time state officer from engaging in meaningful employment. Mr. Speaker, sir, it will be prejudicial to our client if this House was to allow my learned friend, senior James Orengo, to represent the National Assembly in these proceedings. Mr. Speaker, sir, just recently, this House, which is a House of record, we bear as witness that during the impeachment of the Deputy Governor of Kisii County, the County Assembly attempted to appear by legal counsel represented by one Honorable Soro, An objection was raised by my learned friend, Senator Chargei, which objection was sustained by this House. Mr. Speaker, sir, our objection is further premised in the High Court decision, that is High Court Constitutional Petition 204 of 2019, where Justice Ogola barred His Excellency the Governor of Siaya County from representing the then Director General of Kenya Port Authority, one Daniel Maduk. The judgment is before this honorable House that a person who is engaged in full-time employment cannot then purport to appear and represent a party before this assembly. It will raise serious conflict of interests. The same will prejudice our client, and it's also in violation of clear provisions of the law as cited. In that respect, Mr. Speaker, sir, we invite you to uphold our objection before the charges are read out to the to our client. Mr. Speaker, sir, in this ruling that I've just cited, the court was of the view that a person who is engaged in full-time engagement as a state officer cannot and is barred from representing a party in a private capacity. We so beseech you, Mr. Speaker, sir, to uphold our objection. I am most humbled.
Counsel for the National Assembly, if you look at our program, the preliminary objections were to be raised after His Excellency has taken plea. And therefore, we'll allow the clerk to read the charges. Before anything else, I will allow the Counsel for the National Assembly to respond, and therefore I will make my ruling, and then we'll take it from there.
I am most obliged, Mr. Speaker, sir.
Proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. Particulars of the allegations. Your Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, please take the stand. Your Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, the grounds for your proposed removal from office by impeachment, as received by the Senate from the National Assembly, are as follows. Part A, gross violation of the Constitution or any other law pursuant to Article 51(b)(1) of the Constitution. Ground 1, gross violation of Articles 10, 2A, B, and C, 27(4), 73(1)A and 2B, 75(1)C, and 129(2) of the Constitution, and Articles 147(1), as read with Article 131(2)C and D of the Constitution. The preamble of the Constitution provides, among other things, that the people of Kenya adopted and enacted it, A, being proud of the ethnic, cultural, and religious diversity, and a determination to live in peace and unity as one indivisible sovereign nation, and B, recognizing the aspirations of all Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. The preamble of the Constitution is supplemented by Article 10(2)(a), B, and C of the Constitution, which establishes the core national values and principles of governance that bind all state officers, including the Deputy President. These values and principles include patriotism, human dignity, national unity, equity, social justice, inclusiveness, non-discrimination, equality, human rights, protection of the marginalized, democracy, and good governance. Moreover, Articles 73(1)(a) and 2(b) of the Constitution establish responsibilities of leadership. They provide that the authority assigned to a state officer, such as the Deputy President, is a public trust to be exercised in a manner that is consistent with the purpose and objects of the Constitution, demonstrates respect for the people, brings honor to the nation and dignity to the office, and promotes public confidence in the integrity of the office. Also, Article 27(4) of the Constitution prohibits all forms of discrimination, including discrimination based on ethnic or social origin, conscience, belief, language, and birth. Further, Article 73(2)(b) of the Constitution provides that decision-making should be objective and impartial and should not be influenced by favoritism and improper motives. Furthermore, Article 75(1)(c) of the Constitution provides that a state officer should behave, whether in public and official life, in private life, or in association with other persons, in a manner that avoids demeaning the office he holds. Therefore, as a matter of constitutional compliance, the Deputy President of the Republic of Kenya, who is the principal assistant to the President of the Republic, is required, A, to promote the constitutional core values such as peace and unity of all Kenyans in the context of ethnic, cultural, and religious diversity, patriotism, national unity, rule of law, democracy, and participation of the people, equity, social justice, inclusiveness, equality, human rights, non-discrimination, and protection of the marginalized and good governance. B, to respect and uphold representation of Kenya's multi-ethnic and culturally diverse society through the promotion of equality and affording equal opportunities to all Kenyans in appointments to the public service and allocation of public resources. And C, to make, promote, and implement public policy decisions that do not discriminate against any Kenyan based on conscience, ethnic or social origin, language, or birth. However, on diverse dates throughout the last 2 years, His Excellency Rigathi Gachagua has persistently made utterances threatening to discriminate, exclude, and unlawfully deny sections of the people of Kenya and regions of the Republic of Kenya equal opportunities for public service appointments and allocation of public resources. Besides, the utterances are highly inflammatory and insightful and significantly undermine national unity and the peaceful coexistence of Kenya's diverse communities. To illustrate, A, sometime in 2023, at a public forum in Kajiado County within the Republic of Kenya, His Excellency Rigathi Gachagua made highly inflammatory and insightful public pronouncements to the effect that the government of Kenya is a company and that the allocation of government development projects and public sector jobs are based on shares determined by how the populace of the various ethnic communities voted in the 2022 general election. Specifically, he stated as follows, quote, "A government is like a company. There is shareholding. Kuna wale who have invested a lot of shares, kuna wale wameweka kidogo, kuna wale wamekataa, lakini wote ni wa Kenya. So ndio tukasema Kama wewe umeenda kupanda mahindi, ama wacha nipeane example ya ng'ombe kwa sababu niko Kajiado. Wewe uko na ng'ombe yako ya maziwa, hiyo ng'ombe imezaliwa ikiwa njao. Umeichunga vizuri, umepatia majani, umenunulia dairy meal, umepatia chumvi, umepeleka kwa malisho, umepatia maji, imezaa, imeanza kukamuliwa. Wewe unatakiwa kwanza ukue mtu ya kwanza kukamua hiyo ng'ombe na kunywa maziwa. End of quote. His Excellency Rigathi Gachagua emphasized the divisive and insightful narrative embodied in the above utterances as follows. Quote, haiwezekani mtu ambaye alikuwa anakupigia kelele ukichunga hii ng'ombe na kusema hii ng'ombe ni ile ya kienyeji, hakuna haja ya kushughulika naye. Hii ng'ombe ni bure, haiwezi kutoa maziwa. Hii ng'ombe hata ikipona jicho moja, wachana nayo, unapoteza wakati. Saa ile ng'ombe imezaa, imetoa maziwa, amekuja na kikombe, amekuja na sufuria, anataka atolewe maziwa. Mimi nikasema hiyo haiwezekani. Nikasema yule mwenye hii ng'ombe na kuichunga na kuitunza, kwanza akamue maziwa, yeye na watoto wake wakunywe. Ile itabaki aitie majirani. Hata yule alikuwa anapiga kelele akisema hii ng'ombe ni bure na haiwezekani, kama kunayo imebaki pia apewe. Kama hakuna imebaki atembee. Si namna hiyo? End of quote. His Excellency Rigathi Gachagua made similar remarks at another public forum as follows. Quote, a government is like a company. I did not say it is a company. I said it is like a company. In every company, there are shares, preferential shares and ordinary shares. When there is an AGM, non-shareholders do not vote or attend the AGM. When there are dividends to be divided, they are divided according to the number of shares. That is the truth. End of quote. His Excellency Rigathi Gachagua continued the insightful and divisive utterances at yet another forum where he stated as follows. Quote, si lazima tungeangalia nyinyi. Sisi lazima tungeangalia nyinyi. Hii serikali ni kampuni na ni ya shares. Si ndio? Ni ya shares. Kuna wenye kampuni, wale wako na shares mingi, wale wako na chache. Kuna wale hawana. Sasa nyinyi mliinvest kwa hii kampuni ya William Ruto na Rigathi Gachagua. Sasa lazima mvune. Yule ambaye alipanda atafanya nini? Si mlipanda? Si mliamka mapema? End of quote. At another forum in Nandi County, His Excellency Rigathi Gachagua continued the same divisive and insightful narrative as follows. Quote, Raisa ako pale niko hapo. Raisa ako pale niko hapo. Huyu Felix ako hapo. Mimi mnanijua msimamo wangu ya kwamba watoto wakiwa wengi kuna wale kwanza ya kuangaliwa. Si mnajua? Sasa huyu Felix ako pale ndiye kuunganisha mawaya. Mambo yenu tumepanga. Mambo iko sawa. Chakula iko jikoni, karibu kuiva. Watoto ni wengi, chakula ni kidogo. Iko watoto ya nyumbani, iko wajirani. Iko namna hiyo. Na nyinyi mtulie. Chakula ikiiva, sisi ndio wenye kupakua. Na watoto tunawajua kwa sura na kwa msimamo. Hatuwezi kuwa confused. Kuna mtu hajui watoto wake? Na wiki inakuja tutatangaza hatua kali ile tutachukua na ile maneno tumepanga. End of quote. In addition, in September 2024, during a public rally in Nairobi, His Excellency Rigathi Gachagua made public utterances that incited other communities against the ethnic communities that live around the Mount Kenya region by stating as follows, quote, na mimi mkaniambia nimsaidie rais kwa kazi, lakini nikiwa hapo kwa serikali nikuwe pia nikichunga mambo ya watu wa mlima. Niendelee kuchunga mambo ya mlima ama nisichunge? Sasa hiyo kuchunga mambo ya mlima inaniletea matatizo. Ati naambiwa mimi ni mkabila. Mimi ni mkabila kweli? Nikichunga mambo ya watu wa mlima iko makosa? Iko makosa? End of quote. His Excellency Rigathi Gachagua's utterances throughout the past 2 years undermined the promotion of national unity in the context of Kenyan society's multi-ethnic demography.
Clerk, just pause for a bit. Honorable Senators, just put your phones on silence. Please, proceed, Clerk.
Repeat. His Excellency Rigathi Gachagua's utterances throughout the past 2 years undermined the promotion of national unity in the context of Kenyan society's multi-ethnic demography and multicultural diversity. In addition, they have the potential to alienate, isolate, and create disharmony among the various ethnic communities of Kenya. In summary, His Excellency Rigathi Gachagua's above-mentioned utterances over the last 2 years are impeachable offenses to the extent that they grossly violate Articles 10(2)(a), (b), and (c), 27(4), 73(1)(a) and 2(b), 75(1)(c), and 129(2) of the Constitution, and Article 147(1) as read with Article 131(2)(c) and (d) of the Constitution. Specifically, His Excellency Rigathi Gachagua's divisive and insightful public utterances over the last 2 years, A, are incompatible with the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, B, can stir ethnic hatred and promote ethnic balkanization of the Republic of Kenya, C, falsely alluded to an non-existent government policy to discriminate and marginalize the populace of the regions and tribes that did not vote for the current administration in the 2022 general elections. Your Excellency Rigathi Gachagua, how do you plead to ground 1, guilty or not guilty?
Not guilty.
Ground 2, gross violation of Articles 147(1) and 152(1) of the Constitution. Article 147(1) of the Constitution provides that the Deputy President shall be the principal assistant of the President and shall deputize for the President in the execution of the President's functions. In addition, Article 152(1) of the Constitution states that the Deputy President is a member of the Cabinet. On various dates throughout the last 2 years, His Excellency Rigathi Gachagua undermined the President and the Cabinet and the effective discharge of the national government's executive mandate by making unilateral public statements that were inconsistent with policy positions collectively adopted by the government. To illustrate, A, on or around 30th April 2024, the Cabinet passed a resolution for the evacuation of people residing along the Nairobi River. B, shortly after that, His Excellency Rigathi Gachagua made a public statement opposing the Nairobi River riparian evacuation orders, which the Cabinet had sanctioned for public safety and climate change mitigation. His Excellency Rigathi Gachagua made contradictory public statements despite being a member of the Cabinet and being assigned the function of superintending the Nairobi River riparian evacuation order. In addition, His Excellency Rigathi Gachagua has on several occasions throughout the last 2 years made public statements contradicting the President on critical matters of governance and the exercise of the President's functions as a symbol of national unity. To illustrate, in March 2023, at a public forum in the Nyanza region, the President said Kenya belongs to all, notwithstanding how people voted in the 2022 general elections, and that he would ensure the government does not discriminate against anyone. However, His Excellency Rigathi Gachagua, speaking after the President at another public forum, contradicted him by saying that Kenya is a company in which the provision of government services is based on shares. B. His Excellency Rigathi Gachagua has made numerous other utterances at public forums where he publicly restates the divisive narrative that Kenya is a company in which the rights of citizens are based on shares determined by how various ethnic communities voted in the 2022 general elections. His Excellency Rigathi Gachagua's unilateral, divisive, and insightful public statements are impeachable offenses to the extent that A. They undermine the effective discharge of the national government's executive mandate. B. They violate the doctrine of collective responsibility. C. They are equivalent to insubordination of the President, which is incompatible with his constitutional status as the principal assistant to the President of the Republic of Kenya. Your Excellency Rigathi Gachagua, how do you plead to ground 2, guilty or not guilty?
Not guilty.
Ground 3, gross violation of Articles 6.2, 10.2a, 174, 186.1, 189.1, and the 4th schedule to the Constitution, that is, undermining devolution. Article 10.2a of the Constitution provides that devolution is a fundamental national value and principle of governance. In addition, Article 6.2 of the Constitution provides that governments at the county and national levels are distinct and interdependent and shall conduct their mutual relations based on consultation and cooperation. These provisions are supplemented by Article 189(1) of the Constitution, which provides that governments at each level shall perform and exercise their powers in a manner that respects the functional and institutional integrity of government at the other level. Under paragraph 7A of part 2 of the 4th schedule to the Constitution, county governments are responsible for trade development and markets as an exclusive function. Moreover, the Deputy President chairs the Intergovernmental Budget and Economic Council, an essential organ for consultation between the two levels of government. On or around 20th September 2024, His Excellency Rigathi Gachagua, recklessly, unmindful of the high calling and dignified status of the office of the Deputy President of the Republic, unlawfully interfered with the running of Nairobi City County Government by holding a public rally in which he incited citizens against lawful directives of the Nairobi City County Government on the planning and relocation of markets. Further, His Excellency Rigathi Gachagua publicly disparaged the leadership of the Nairobi City County Government and its decisions. Moreover, His Excellency Rigathi Gachagua has interfered with the proper discharge of county government's constitutional functions regarding alcohol control and regulation. His Excellency Rigathi Gachagua's insightful and demeaning public statements and conduct are impeachable offenses to the extent that A. They undermine devolution, B. They undercut the functional and institutional integrity of county governments, C. They unjustifiably vilify and ridicule the leadership of county governments, especially the Nairobi City County Government. Consequently, His Excellency Rigathi Gachagua has grossly violated Articles 6.2.
Clerk, just a minute. I realize what you're reading is fairly long. His Excellency the Deputy President, if you may sit, and when taking the plea, you may stand.
No, Mr. Speaker, let me stand.
You may proceed, Clerk.
I repeat, consequently, His Excellency Rigathi Gachagua has grossly violated Articles 6.2, 10.2a, 174, 186.1, and 189.1 of the Constitution, as read with the 4th schedule to the Constitution. Your Excellency Rigathi Gachagua, how do you plead to ground 3, guilty or not guilty?
Not guilty.
Ground 4, gross violation of Article 161 of the Constitution, that is, undermining the institutional and decisional independence of judges. Article 161 of the Constitution provides that the judiciary shall be subject only to this Constitution and the law, and shall not be subject to the control or direction of any person or authority. Many international law instruments, treaties, and principles require the guarantee of the judiciary's independence and require all government officers and institutions to respect and observe it. In 2023, His Excellency Rigathi Gachagua, recklessly, unmindful of the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, and the need to respect, protect, and uphold the independence of the judiciary, made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition for the removal of the said judge in gross violation of Article 165 of the Constitution. The Honorable Judge had presided over a case in which His Excellency Rigathi Gachagua was a party and had, in the lawful performance of her judicial function, ordered His Excellency Rigathi Gachagua to forfeit to the state the sum of Kenya shillings 200 million, which she had found to be proceeds of corruption and money laundering. His Excellency Rigathi Gachagua's public attacks against the judge are impeachable offenses to the extent that they undermine the functional and decisional independence of judges. Your Excellency Rigathi Gachagua, how do you plead to ground 4, guilty or not guilty?
Not guilty.
Ground 5, gross violation of Articles 3.1 and 148.5a of the Constitution, that is, breach of the oaths of office and allegiance. His Excellency Rigathi Gachagua's actions and utterances outlined in grounds 1, 2, 3, and 4 constitute a gross violation of Article 3.1 of the Constitution, which requires every person to respect, uphold, and defend the Constitution. Further, the actions and utterances of His Excellency Rigathi Gachagua grossly violate Article 148.5a of the Constitution, which prescribes the oath of allegiance of the office of the Deputy President, that obligates the Deputy President to obey, preserve, protect, and defend the Constitution and all other laws. Your Excellency Rigathi Gachagua, how do you plead to ground 5, guilty or not guilty?
Not guilty.
Part B, serious reasons to believe that the Deputy President has committed a crime under national law pursuant to Article 151b(2) of the Constitution. Ground 6, serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Sections 13(1)(a) and 62 of the National Cohesion and Integration Act. Section 13 of the National Cohesion and Integration Act provides that it is an offense for any person to use threatening, abusive, or insulting words or behavior where the person intends to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. The section also makes it an offense to use such words or engage in such behavior when, having regard to all the circumstances, ethnic hatred is likely to be stirred up. Besides, Section 62 of the National Cohesion and Integration Act states that a person commits an offense when the person makes statements that are intended or are likely to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. His Excellency Rigathi Gachagua's persistent, inflammatory, reckless, insightful public utterances over the last 2 years, the details of which are set out in grounds 1, 2, 3, and 4, establish serious reasons to believe that he has committed crimes under Section 13(1) and 62 of the National Cohesion and Integration Act. Your Excellency Rigathi Gachagua, how do you plead to ground 6, guilty or not guilty?
Not guilty.
Ground 7, serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under sections 45(1), 46, 47A(3), and 48(1) of the Anti-Corruption and Economic Crimes Act, and sections 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. For the past 2 years, His Excellency Rigathi Gachagua has inexplicably amassed a humongous property portfolio estimated at Kenya shillings 5.2 billion, primarily from proceeds of corruption and money laundering. The value of the property and wealth that His Excellency Rigathi Gachagua has acquired over the last 2 years is incompatible with his non-legitimate income, that is Kenya shillings 12 million per annum or thereabouts. His Excellency Rigathi Gachagua has acquired the above-mentioned property and wealth using his 2 sons, Kevin Rigathi Gachagua, that is Kevin Gachagua, and Keith Ikinu Rigathi, that is Keith Ikinu, and other close family members and associates as proxies. His Excellency Rigathi Gachagua and his proxies, especially the 2 sons, have used the following companies to massively launder money, conceal proceeds of crime, corruption, and benefit from influence peddling. Number 1, Spiritway Limited, PVT-Y2ULDMKY, date of incorporation 14th of September 2023, shareholders Dorcas Wanjiko Rigathi, who is director, stroke shareholder, stroke beneficial owner with 100 shares. 2, Fortis Viz Group Limited, PVT-MKUMAKEE, date of incorporation 14th of February 2023, shareholders Kevin Rigathi Gachagua with 50 shares and Keith Ikinu Rigathi 50 shares. 3, Grand Bypass Apartments Limited, PVT-5JUZEKL8, date of incorporation 11th of January 2024, shareholders Rigathi Gachagua, director, John Mwai Madenge of 7676931 as director, Peter Njoroge Regeru, number 4686103, director, Vipingo Beach Resort Limited, number C159289, shareholder with 1 share. 4, Kuruwitu Properties Limited, PVT-EYUBKG83, date of incorporation 26th of April 2023, shareholders Vipingo Beach Resort Limited, number C159289, as shareholder with 1,000 shares, and John Mwai Madenge. Number 5, the Anansi Collective, BN-JRCG76AG, date of incorporation 29th of March 2021, shareholders Keith Dorcas Wanjiko Rigathi 200 shares. 7, Calvary Creed International Limited, number CPR/2015/186154, date of incorporation 16th of April 2015, shareholders Rigathi Gachagua with 50 shares, Dorcas Wanjiko Rigathi 950 shares. 8, Cosmia Venture Limited, number PVT-Q7ULE6Z, date of incorporation 26th of February 2018, shareholders Herman Dhoita Maina 200 shares, James Mwangi Kagodho 50 shares, Kevin Rigathi Gachagua 250 shares, Keith Ikinu Rigathi, 50 shares. Irene Nyanjao Washira, 250 shares. And David Kipkemboi Mudhamia, 200 shares. Number 9, Cristo Kenya Limited, number CPR stroke 2009 stroke 4898, date of incorporation 12th of June 2009, shareholders Kevin Rigathi Gachagua, 200 shares, Keith Ikinu Rigathi, 200 shares. 10, Delta Merchants Limited, number CPR stroke 2009 stroke 4874, date of incorporation 9th of June 2009, shareholders Rigathi Gachagua, 200 shares, Dorcas Wanjiko Rigathi, 200 shares. 11, Vipingo Beach Resort Limited, number C159289, date of incorporation 5th of August 2008, shareholders Kevin Rigathi Gachagua as director, Keith Ikinu Rigathi, director, estate of the deceased James Nderito Gachagua, shareholder with 10,000 shares. 12, Rigathi Gachagua Foundation, number CLG-XXFXRG, date of incorporation 11th of November 2022, shareholders Rigathi Gachagua. 13, Dorcas Rigathi Foundation, number CLG-G9FV2G, date of incorporation 19th of October 2022, shareholders Kevin Rigathi Gachagua, Keith Ikinu Rigathi, Dorcas Wanjiko Rigathi, Nancy Wamboi Kang'ethe. 14, Heartland Supplies Limited, number CPR stroke 2009 stroke 4881, date of incorporation 11th of June 2009, shareholders Rigathi Gachagua, director as director stroke shareholder with 200 shares, Dorcas Wanjiko Rigathi as director and shareholder with 200 shares. 15, Karandi Farm Limited, number C94303, date of incorporation 25th of June 2001, shareholders Rigathi Gachagua as director, shareholder with 700 shares, Dorcas Wanjiko Rigathi as director and shareholder with 100 shares. 16, Morani Manufacturers Limited, number PVT-8LU7Q8GD, date of incorporation 13th of October 2021, shareholders Dorcas Wanjiko Rigathi as director and shareholder, 200 shares, Keith Ikinu Rigathi, director and shareholder, 200 shares, Joshua Karianjahi Waiganjo, director, shareholder, 600 shares, and Grace Washuka Mwangi, beneficial owner. 17, Mothers of the Land Limited, number CLG-55FD3B, date of incorporation 1st of December 2021, shareholders Louisa Njeri Wanjiro, director stroke member, Caroline Jepkemboi Waiyaki, director stroke member, Lucy Njogoine Mutegi, director stroke member, Dorcas Wanjiko Rigathi, director stroke member. 18, Pioneer Medical Kenya Limited, number CPR stroke 2009 stroke 4910, date of incorporation 9th of June 2009, shareholders Rigathi Gachagua as director stroke shareholder, 200 shares, Dorcas Wanjiko Rigathi, director and shareholder, 200 shares. 19, Ryder Furniture Mart Limited, number C141876, date of incorporation 18th of July 2007, shareholders Rigathi Gachagua as director and shareholder, 500 shares, Dorcas Wanjiko Rigathi as director and shareholder, 500 shares. 20, Royal Crimson Ventures Limited, number PVT-LRU2QZL, date of incorporation 26th of February 2018, shareholders Kevin Rigathi Gachagua as director and shareholder with 400 shares, Keith Ikinu Rigathi as director and shareholder 400 shares, and Peter Kangagi Githaiga as director and shareholder 200 shares. 21, Technical Supplies and Services Limited, Kenya Limited, date of incorporation 6th of June 2009, shareholders Rigathi Gachagua as director, shareholder with 400 shares. Sorry, I said that again. 21, Technical Supplies and Services Kenya Limited, CPR 2009/4895. Date of incorporation is 6th of June 2009. Shareholders are Rigathi Gachagua, director, shareholder with 400 shares, and Francis Moshiri Wanguo, director. And 22, Wamunyoro Investments Limited, number C93670936670, date of incorporation 23rd of April 2001. Shareholders Kevin Rigathi Gachagua as director, shareholder with 1 share, and Keith Ikinu Rigathi, director, shareholder with 1 share. To illustrate, in November 2023, Cristo Kenya Limited, number 9 in the above table, a proxy company of His Excellency Rigathi Gachagua, purchased Outspan Hotel, situated at Nyeri Municipality Block /1/1669 from Aberdare Safari Hotels for Kenya shillings 535 million. The directors of Cristo Kenya Limited are the sons of His Excellency Rigathi Gachagua, namely Kevin Gachagua and Keith Ikinu. Sometime in August 2024, His Excellency Rigathi Gachagua publicly admitted that his family had acquired this property. B. In November 2023, Kevin Gachagua and Keith Ikinu, the proxies of His Excellency Rigathi Gachagua, acquired Treetops Lodge, a high-end hotel situated in Nyeri County. Sometime in August 2024, His Excellency Rigathi Gachagua publicly admitted that his family had acquired this property. C. His Excellency Rigathi Gachagua and his proxies also acquired Olive Gardens Hotel and Queensgate Serviced Apartments in Nairobi. D. His Excellency Rigathi Gachagua acquired Vipingo Beach Resort in Kilifi County. E. His Excellency Rigathi Gachagua acquired a parcel of land known as Rogoro-Kiamariga/1223 in Madera East constituency, where he constructed a helicopter landing facility. F. His Excellency Rigathi Gachagua acquired approximately 40 acres of land in Kakuret in Kamburaine in Nyeri County. G. His Excellency Rigathi Gachagua acquired 80 acres of land in Meru County. H. His Excellency Rigathi Gachagua acquired a dairy farm in Nyandarua County. I. Additionally, His Excellency Rigathi Gachagua used his office of Deputy President to exert influence and connive with unscrupulous Ministry of Lands officials to issue an allotment letter to Wamunyoro Investments Limited, a company that he owns, to acquire LR 209/12077 and LR 90923, situated at Embakasi in Nairobi, whose value is estimated at Kenya shillings 1.5 billion or thereabouts. After that, this company used the fraudulently acquired documents to support a court case at the expense of the legitimate owner of the property. J. Moreover, companies associated with His Excellency Rigathi Gachagua and his proxies were involved in the KEMSA Kenya shillings 3.7 billion irregular procurement of malaria nets that put the lives of millions of Kenyans at risk. K, in addition, His Excellency Rigathi Gachagua has used the office of Deputy President to corruptly influence unnecessary and expensive renovation of his official residence in Karen and Mombasa, running into millions of shillings. In essence, His Excellency Rigathi Gachagua has chosen personal comfort, extreme luxury, and pomposity at the expense of service delivery to the people of Kenya. L, images of some of the properties that His Excellency Rigathi Gachagua has acquired from proceeds of corruption, influence peddling, and money laundering have been provided and relate to the following. 1. Treetops Hotel, located in Nyeri. 2. Outspan Hotel, located in Aberdare Ranges. 3. Olive Gardens Hotel, Agwings Kodhek Road. And 4. Vipingo Beach Resort. Additionally, His Excellency Rigathi Gachagua has the following proxy companies to trade with the office he holds. A. Agrobrick Investments Limited. It is a private limited company incorporated in Kenya on 28th May 2017 under certificate number PVT-RXUP6E. The company deals in building and construction. The company's directors / shareholders are A. Rudani Mayur Kumar Mahendrabai, and B. Patel Ankit Kumar Hasmukbai, an Kenyan national. 48. The company operates a bank account, number withheld for data protection reasons, at Sidian Bank, opened on 19th February 2022, with the company directors as the account signatories. On 18th October 2022, Bhavika Nathalal Hirani was added as an account signatory and given the full mandate to operate the account. Bhavika Nathalal Hirani is a proxy of His Excellency Rigathi Gachagua. On 23rd January 2023, the company account received a transfer of Kenya shillings 47,015,367 shillings and 75 cents from the Executive Office of the Deputy President. The payment was supported by A. Notification of award letter, reference number ADM/ADM.1/57 VO.4/70 dated 16th December 2022 from the Office of the Deputy President to Agrobrick Investment Limited for the proposed refurbishment of Deputy President's official residence at Karen at a cost of Kenya shillings 55,559,520. B. Payment voucher of Kenya shillings 55,133,265.92 was received on 10th January 2023 as the first interim payment in respect of the contract ODP-RT-001, ODP/RT-001/2022-2023. C. An agreement letter dated 22nd December 2022 between Office of Deputy President and Agrobrick Investment Limited for the proposed renovation of Deputy President's official residence in Karen. Bhavika Nathalal Hirani signed the document as a director of Agrobrick Investment Limited. On 23rd January 2023, the funds were suspiciously transferred through a transfer of Kenya shillings 45 million to a related entity, that is Vaggiani Enterprises Limited. Shockingly, the account had been dormant for around 9 months before it received the payment from the Office of the Deputy President, adding to the reasonable suspicion that it was a special purpose vehicle to siphon funds for His Excellency Rigathi Gachagua. B. Lusona Events Limited. This is an events management company that was registered on 30th of October 2012 under certificate number CPR/2012/87037. The company directors are A. Esther Wanjiro Njenga and B. Cecilia Mudhoni Njenga. The company operates two accounts at the SBM Bank, which it opened in 2015. The company's directors are account signatories. Ian Njuguna Gitata was also introduced as an account signatory and is the sole account operator, pointing to the likelihood that he is the beneficial owner. Between 1st January 2024 and 11th July 2024, the account at SBM Bank received a total of 100 million shillings, 262,821.43 cents from the Office of the Deputy President, characterized by the receipt of multiple transfers. On 2nd of July 2024, the Deputy President's Office paid Lusona Events Limited part of the above-mentioned proceeds of corruption and money laundering in 8 transactions in a single day as follows. On 2nd of July 2024, the amount of 2,946,900. Secondly, on 2nd of July 2024, the amount of 4,806,639 shillings. Thirdly, on 2nd of July 2024, the amount of 4,679,130 shillings. Fourthly, on 2nd of July 2024, the amount of 2,955,450 shillings. Fifth, on 2nd of July 2024, the amount of 3,374,400 shillings. Sixthly, on 2nd of July 2024, the amount of 5,451,912 shillings and 40 cents. Number 7, on 2nd of July 2024, the amount of 3,582,536 shillings and 50 cents. And number 8, on 2nd of July 2024, the amount of 3,840,625 shillings and 60 cents. A substantial portion of the Kenya shillings 100,262,821 and 43 cents was used for luxurious largesse and unnecessary expenditure for carpets, etc., laid down for the Deputy President's functions. Some of the funds were utilized as follows. A. Ian Gitata made Kenya shillings 22,800,000 in cash withdrawals. Some of the withdrawals were declared as cash to pay undisclosed beneficiaries. It was suspicious why they preferred cash payments opposed to bank transfers. B. Kenya shillings 4 million transferred to a law firm. C. Kenya shillings 26,993,350 investment in fixed term deposits as follows. 1. On 27th of May 2024, Kenya shillings 9,993,350. 2. On 11th July 2024, Kenya shillings 17 million. The utilization of funds was reasonably believed to be an act of corruption and money laundering, as most of the money was withdrawn in cash rather than bank transfers, which is a custom for huge payments. His Excellency Rigathi Gachagua is reasonably suspected to be the principal beneficiary of these dubious transactions. C. St. Nicholas Rehabilitation and Industrial Training Institute Limited. The company was incorporated on 8th of April 2021 under registration number PVT-AAACMO4. It deals with student rehabilitation and industrial training, trading as St. Nicholas Rehabilitation Center and Psychiatric Hospital. The sole company director is Nicholas Mugambi Maingi. The company operates an account at Equity Bank, opened on 18th August 2017, with the company director as the sole account signatory. Between 1st March 2024 and 5th June 2024, the account received a total of Kenya shillings 21,060,000 from the office of the Deputy President. The funds were suspiciously utilized as follows. A. Kenya shillings 2 million was allegedly used to purchase a white Toyota Prado from Umarali Motors Limited for Kenya shillings 8.5 million. B. Another Kenya shillings 4 million was suspiciously transferred to Nicholas Maingi's account. A cash trail in the personal account revealed that upon receipt of the funds, Nicholas made a transfer of Kenya shillings 4,660,000 to Umarali Motors Limited on 21st March 2024. The purported payment to Umarali Motors Limited using two routes raises reasonable suspicion of corruption and money laundering. Further, prior to receipt of the two payments from the Office of the Deputy President, the account was transacting in minimal accounts, raising suspicions that the entire transaction was a conduit used by His Excellency Rigathi Gachagua to siphon public funds. The payment scheme used typifies money laundering transactions. From the matters outlined in the preceding parts, it is patently clear that there are serious reasons to believe that His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, using his state office, has committed gross economic crimes, namely conflict of interest, abuse of office, conspiracy to commit crimes under A. Sections 45(1)(a), 46, 47(a)(3), and 48(1) of the Anti-Corruption and Economic Crimes Act, and B. Sections 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. Your Excellency Rigathi Gachagua, how do you plead to count 7, guilty or not guilty?
Not guilty.
Round 8, serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. His Excellency Rigathi Gachagua has continuously misled members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. To illustrate, sometime in January 2024, His Excellency Rigathi Gachagua made a sensational but false accusation that Honorable Justice Esther Maina, Judge of the High Court of Kenya, had engaged in corruption. He publicly said he would present a petition for the removal of the said judge, which he has not done to date, leading to the inevitable conclusion that he knew his allegations were false. On or about 26th of June 2024, His Excellency Rigathi Gachagua, recklessly and unmindful of the high calling and dignified status of the Office of the Deputy President of the Republic and his membership to the National Security Council, both being positions that require one to be a discreet and tempered leader, especially during moments of national crisis, addressed Kenyans on live television in Mombasa County and publicly made sensational statements against the National Intelligence Service, an essential national security organ, its director and officers. The following is an excerpt of part of his speech. I quote, "The Director General of the National Intelligence Service, Nurdin Haji, was a junior officer in the National Intelligence Service before he was appointed as DPP. When he was appointed to the office of the Director General, because of his inferiority complex, He chased away all the people who were senior to him when he was in the service, therefore crippling the capacity of that service and making it dysfunctional. 3 directors were chased away and reassigned to desk jobs in ministries across government. 13 assistant directors, men and women with proven track record of intelligence collection and analysis, were removed from the National Intelligence Service, leaving a shell and a clueless Director General who has no capacity to run the organization. And that is why the security sector was caught off guard by the intensity, the anger of the Kenyan people, the agitation of the Kenyan people, the resilience of the Kenyan people. End of quote. Your Excellency, Rigathi Gachagua, how do you plead to ground 8, guilty or not guilty?
Not guilty.
Part C, gross misconduct pursuant to Article 151B(3) of the Constitution. Ground 9, gross misconduct, that is public attacks on National Security Intelligence Service and its officers. The phrase gross misconduct generally refers to behavior that is, quote, very unpleasant, disgusting, or very rude. This is from the Oxford Advanced Learners Dictionary. Therefore, public attacks against an essential national security organ in circumstances that require one to be discreet and tempered constitute gross misconduct. On or around 26th of June 2024, His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, unmindful of the high calling and dignified status of the office of the Deputy President of the Republic of Kenya and his membership to the National Security Council, both being positions that require a leader to be discreet and tempered, especially during moments of national crisis, addressed Kenyans on live television in Mombasa County and made a scathing attack on the National Intelligence Service, an essential national security organ. His Excellency Rigathi Gachagua extended the extremely reckless personal attacks to the Director General of the institution. With the unprecedented acts, His Excellency Rigathi Gachagua acted in a manner that is incompatible with the high calling and dignified status of the office of the Deputy President and member of the Cabinet and the National Security Council. The attacks against the National Intelligence Service and its Director General constitute gross misconduct and an impeachable offense to the extent that A, they are incompatible with the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, B, they undermine national security from both internal and external points of view, C, they are incompatible with the effective discharge of the delicate and sensitive mandate of the National Intelligence Service, D, they had the potential, given the circumstances prevailing in the country at the time, to significantly diminish public confidence in the viability of the Kenyan state and its ability to protect the lives and properties of its citizens. E, they go against the constitutionally prescribed oath of allegiance of the office of the Deputy President under Article 148(5)(a) of the Constitution, which requires the Deputy President to obey, preserve, protect, and defend the Constitution and all other laws. Your Excellency Rigathi Gachagua, how do you plead to ground 9, guilty or not guilty?
Not guilty.
Ground 10, gross misconduct, that is insubordination. As stated in ground 9, the phrase gross misconduct generally refers to behavior that is very unpleasant, disgusting, very rude. This is from the Oxford Advanced Learners Dictionary. Therefore, open or public insubordination of the President, who is the head of state and government under our constitutional framework, is gross misconduct. As stated in the preceding parts, Article 147(1) of the Constitution designates the Deputy President as the principal assistant of the President, who shall deputize for the President in the execution of the President's functions. His Excellency Rigathi Gachagua has persistently undermined, demeaned, and committed insubordination instead of assisting the President in executing the state executive mandate. Instead, he has opted to run a smear campaign against the presidency for political expediency. Further, whereas Article 147(2) of the Constitution requires the Deputy President to perform the functions conferred by the Constitution and any other functions that the President may assign, His Excellency Rigathi Gachagua is openly sabotaging the state's efforts in agriculture, including the coffee, tea, sugar, and milk sectors, which the President tasked him to oversee. To illustrate, A, His Excellency Rigathi Gachagua has connived with cartels in the tea sector to block the Kenya Tea Development Agency from implementing guaranteed minimum returns that would benefit smallholder tea farmers. B, His Excellency Rigathi Gachagua has influenced his family members, allies, associates, and proxies to take control of a local cooperative society, name withheld in Madeira, which they are financially hemorrhaging. Your Excellency Rigathi Gachagua, how do you plead to ground 10, guilty or not guilty?
Not guilty.
Ground 11, gross misconduct, that is bullying. As stated in ground 9, the phrase gross misconduct generally refers to behavior that is very unpleasant, disgusting, or very rude. This is from the Oxford Advanced Learners Dictionary. Section 34 of the Leadership and Integrity Act provides that a state officer shall not bully any person. Bullying includes repeated offensive behavior that is vindictive, cruel, malicious, or humiliating, and is intended to undermine a person. For the past 2 years, His Excellency Rigathi Gachagua has persistently bullied state and public officers. To illustrate, A, His Excellency Rigathi Gachagua bullied Kenya Medical Supplies Agency officials into awarding a tender for the supply of mosquito nets to Crystal Limited, his proxy company. Crystal Limited has submitted a fake bid bond with the sole intention of fraudulently acquiring public property. B, His Excellency Rigathi Gachagua routinely bullies public officers in national security organs whom he subjects to public attacks and humiliation. C, His Excellency Rigathi Gachagua routinely summons procurement officers in ministries and state institutions and instructs them to direct the procurement of goods and services in a particular manner. D, in the presidency, His Excellency Rigathi Gachagua identified public officers who he thinks stand in his way of creating dominance within government and political kingship, and he has severely threatened, intimidated, and harassed them. E, in 2023, His Excellency Rigathi Gachagua used his position as a deputy president to intimidate public officers and a contractor to divert materials meant for the construction of the Kilifi-Malindi Road to tarmac a private road to Vipingo Beach Resort, a hotel associated with him. F, His Excellency Rigathi Gachagua uses his constitutional power as deputy president solely to implement sectarian, parochial, and personal interests that seek to profit him. Your Excellency Rigathi Gachagua, how do you plead to ground 11? Guilty or not guilty?
Not guilty.
His Excellency the Deputy President, you may take your seat. Counsel for the National Assembly, you may proceed to respond to the objection that has been raised by Counsel for the Deputy President.
Perhaps, Mr. Speaker, sir, just before Council announced my application, for efficiency and expediency, permit me also to bring to the attention one more application in respect to the documents that were served upon the Deputy President. Mr. Speaker, sir, by a letter that you referred to, sent from the Speaker of the National Assembly to the Speaker of the Senate, The Speaker of the National Assembly did submit the documents that emanated from the National Assembly.
Counsel for the Deputy President, take your seat first. You'll have your moment.
Mr. Speaker, sir, if I could take a few moments this afternoon to respond to the preliminary objection that has been raised. I have three quick issues in response to that objection. Number one, the Constitution of Kenya at Article 77 is the primary law that then speaks to restrictions on activities of state officers. In particular, Article 77(1) reads, "A full-time state officer shall not participate in any other gainful employment." Mr. Speaker, sir, that article introduces one critical variable: gainful employment. Mr. Speaker, sir, gainful employment has been defined within our laws. Specifically, Section 26 of the Leadership and Integrity Act has defined what would amount to gainful employment. If I may, Mr. Speaker, sir, Section 26(1) reads, "Subject to subsection 2, a state officer who is serving on a full-time basis shall not participate in any other gainful employment." It then proceeds at subsection 2 to say, in this section, gainful employment means work that a person can pursue and perform for money or other form of compensation or remuneration which is inherently incompatible with the responsibilities of the state office, or which results in the impairment of a judgment of a state officer in the execution of the functions of a state office, or results in a conflict of interest in terms of Section 16. And so to our response, there has been no assertion that learned senior counsel James Orengo, by representing a party before this House, has participated in gainful employment. In any case, what evidence has been tendered before this Honorable House to speak to that fact? Mr. Speaker, sir, that is a question that has also received judicial interpretation. If I may, in the election petition number 3 of 2013 filed in the High Court in Busia, a similar application was made, again objecting to the participation of the Honorable James Orengo Senior Counsel in the proceedings in that matter. The judge handling that case interpreted both Article 77 as read with Section 26 of the Leadership and Integrity Act, and had this to say, at paragraph 28, that it had been argued that by representing a party in an election petition, the Honorable Senator would be compromising the political neutrality of his office. I would not agree. Section 23 of this Act is a provision on political neutrality expected of appointed state officers. Honorable Orengo holds an elective position. Elected members of Senate are politicians. The provisions of Section 23 do not apply to them. So even if it was to be assumed that, that by representing the third respondent, Honorable Orengo is pursuing a political agenda, that would not be inimical to his office as a member of the Senate. And so, Mr. Speaker, I submit that unless there is material that will be tabled before this House, that by appearing for a party before this House, then the Honorable Mr. James Orengo Senior Counsel would have engaged in gainful employment. That objection does not stand any merit. Number two, the second test that has been applied by courts is the test around conflict of interest. Again, Mr. Speaker, our courts have had occasion to interpret what amounts to conflict of interest. In a case determined by a 5-judge bench, a case reported in our laws, that is EKLR 2018, the case of Philomena Mbete Mwilu versus the DPP and two others, the bench, in determining and dismissing a similar application, defined conflict of interest as a situation where one is confronted by two different interests, so that serving one interest would be against the other. Mr. Speaker, sir, there hasn't been any conflict of interest that has been, even in the least, mentioned by the objector to the participation of Senior Counsel, the Honorable James Orengo. Finally, has there been an indication as to any prejudice that could be occasioned by the participation of the Honorable James Orengo Senior Counsel before this House this afternoon? To the best of my recollection, none has been mentioned. Is Counsel, for instance, saying that the participation of the Honorable James Orengo before the proceedings in this House would be such that they would fundamentally impair their defense when they get the opportunity to present the case? I'm just asking myself. That has not been said. In any case, Mr. Speaker, sir, if that was to be the case and the fear that has been presented, then as advocates, as counsel, we operate within very clear and defined rules. Those rules are meant to ensure that a party before this House, just like would be a party before any court or any other forum, does not suffer or does not have a compromise to their rights to fair hearing under Article 50. In the absence of any prejudice that has been mentioned before you, we urge that that objection be dismissed. I've also had occasion to look at the case that was referred to by my learned friend, Mr. Njiru, and with respect, that case turned on two critical points. The first one being that the participation of the Honorable James Orengo as a senator in that matter was said to have had the potential of compromising his participation in the Senate proceedings, because then he was a senator. He is not a senator as we speak. So that then marks a significant difference or departure between what led to the finding in that decision and what we have before you. The judge in that specific matter also went on to add that there must also be established a question or a fact of benefit. Again, I reiterate that no indication, no evidence, or even assertion has been presented before this House to suggest that the Honorable James Orengo Senior Counsel has in any way benefited by being in this House participating as counsel. So with that, Mr. Speaker, sir, we urge that that objection be dismissed. I am most obliged.
Thank you, Counsel, for His Excellency the Deputy President.
Thank you, Mr. Speaker, sir. And in brief response to the submissions by my learned friend, there is no denial that has come from Counsel's defense that Senior Counsel Honorable James Orengo is here on pro bono basis. That evidence has not been brought. That claim has not been denied. He's therefore here as counsel earning a fee, and that is what Section 26.
Senior Counsel, don't go to that line of argument. If the evidence of him acting pro bono has not been laid on the table, has the evidence of him earning been put on the table?
Mr. Speaker, sir, The only presumption...
No, we are not going to presume facts. We are not.
Mr. Speaker, sir, I am well guided, but may be noted and may go on record that the grounds laid by Section 26, subsection 2, have not been rebutted by the submissions made by Council insofar as the gainful employment in these proceedings is concerned. Number 2, he is here as a governor of Siaya County, not as a senator. And as such, the petition number 3 of 2013 is distinguishable from the fact that he's here as a serving governor. And that is what Section 26, subsection 2 speaks to, and that is also equally the provisions of Article 77 of the Constitution. Further to that, Mr. Speaker, sir, the test of prejudice is a creation by Council. It is not the one that at Section 26, subsection 2, and Article 77 speaks to. The only test is gainful employment. Unless that one is rebutted, the general presumption, again, Your Lordship and Mr. Speaker, sir, and that is a legal presumption, unless it is rebutted, is that he is here for a main purpose to earn a living. Mr. Speaker, sir, I leave that to the House to make a determination. Permit me once more to move the House with my last and final application. Yeah, insofar as, Mr. Speaker, sir, these proceedings are in issue. Mr. Speaker, sir, on the 8th of October, 2024, this House was served with a resolution from the National Assembly by the Speaker of the National Assembly via the letter that the Speaker of the Senate referred to. That letter, Mr. Speaker, sir, appears at page 547 to 548 of volume 5 of the National Assembly's bundle of document. There is no, Mr. Speaker, sir, we were then served with 2 sets of documents, an affidavit dated the 11th of October, deponed by one Peterson Jomo Mushira. Our objection, Mr. Speaker, sir, is that that document, that affidavit, did not form part of the documents that were submitted by the Speaker of the National Assembly to the Speaker of the Senate. It's our argument, Mr. Speaker, sir, that this is new evidence. Further to that, Mr. Speaker, sir, we were equally served with a bundle of documents from the National Assembly, which is labeled as Volume 8A, which is also indicated as responses from various government agencies. Again, Mr. Speaker, sir, this is new evidence that does not find itself at page 547 to 548 of the bundle of documents submitted to you or to this Honorable House by the Speaker. The prejudice, Mr. Speaker, sir, is that our response was exclusively limited to the documents that we were served with. Further to that, Mr. Speaker, sir, it's our argument and our application that these documents will prejudice our case in the sense that, Mr. Speaker, sir, they will violate our rights to a fair hearing. This is trial by ambush by the National Assembly. It's a tradition of this House, Mr. Speaker, sir, and I refer to the findings of this House in the Honorable Governor Sonko in a ruling delivered by the Speaker of this House on the 17th of December, which ruling barred the County Assembly of Nairobi from introducing any new evidence. It has been the tradition of this House to protect all the parties that appears before it, so that, Mr. Speaker, sir, justice will not only be done, but will also seen to be done. We move this House to have these documents expunged from record, and the National Assembly be barred from relying on these documents. Mr. Speaker, sir, if these documents will be admitted, we shall suffer prejudice in the sense that we shall have no ability, or we shall have been denied an opportunity to respond to the same. We urge you, Mr. Speaker, sir, to hold that these documents is new evidence, and we rely on Rule 19 of this House rules. Noting that, Mr. Speaker, sir, the rules guiding these proceedings today do not provide for how to deal with new evidence as and when the same is brought to the attention of the House. However, the rules guiding proceedings in the impeachment of a governor or deputy governor provides that new evidence shall not be admitted. Further to that, Mr. Speaker, sir, permit me to bring to your attention the findings in the case, in the civil appeal number 21 of 2014, which was the case of Governor Wambora versus the County of Assembly of Embu. Mr. Speaker, sir, in that case, Justice Odiek, may the Lord rest his soul in peace, Chief Justice Martha Koome, as then was, and Justice Vishram held that these proceedings of the impeachment of a president or deputy president are paramateria to the impeachment of a governor. That is to say, they are identical. So what applies in those rules in the impeachment of the governor can equally and should equally apply to these rules. And finally, this House being a House of record, then we are bound by our previous precedents. I am most obliged.
Now, Counsel for the National Assembly, you have 1.5 minutes to respond. You may respond now, or you may respond after the lunch break.
All right. Mr. Speaker, sir, I could respond shortly after the lunch break.
Under our rules, we have to rise at 1:15.
Permit me then to respond after the lunch break. Most obliged.
So, honorable members, I will deliver ruling at 2:30 and then allow the Counsel for the National Assembly to proceed to respond to the second limb of the objection.
Mchwa tena. Siri ni gradometer.
Angamiza mchwa kwa kutumia gradometer, the #1 termiticide in Kenya, kutoka Kenagro Suppliers Limited.
Comprehensive plans often cover dental and optical care, which may not be included in basic health insurance plans.
Go with the flow, every end's a Life's too short to just be living.
My name is John Dungu Mwangi from Subukia. I am a teacher by profession. I've been participating in Aviator for quite some time. I've been praying that one day luck will be on my side. I'll continue playing because there are stakes there that are higher than what I got. I won big on Shabiki Aviator.
Changamkia Aviator on Shabiki.com. Not for persons under the age of 18. Authorized and regulated by PCLB license number 428.
When you've gotta go, go for Neptune, the softer two-ply tissue paper, available in plain white and colored.
When looking for a great washing powder, ensure the powder can handle common stains and maintain its effectiveness with natural ingredients.
Explore the nature and create from it. The spirit of inventors leads to the inspiration for new technology. Join us, Cleasoft Invent for Life.
Uwezi chukua chuma mbaya unataka kutengeneza nayo kitu mzuri Indiani. Chuma ya Doshi haina twist. Chuma ya Doshi iko straight kabisa.
Doshi Steel, chuma ya nguvu.
The evidence they planted against my Aunt Christina has been analyzed by authorities. And now she's going to be sent to prison so fast.
Asante sana mtazamaji kwa kuungana nasi hivi sasa, ikiwa ni mwendo wa saa 7 mchana na dakika 20. Karibu kwenye Sema na Citizen. Tutakuwa tunang'amua masuala ambayo yamejiri katika bunge la Seneti, hii ikiwa ni mara ya kwanza katika historia ya taifa hili Naibu Rais katika Jamhuri ya Kenya kufika katika bunge la Seneti na kuhojiwa na kusomewa mashtaka yake kabla ya siku ya kupiga kura ya ndio au la ya kumuondoa mamlakani, ambayo inatarajiwa itakuwa siku ya kesho. Hapa studioni nina mgeni wetu wakili Kenneth Chesa, atanisaidia katika kuchambua masuala ambayo yameweza kujiri, na pia vile vile tutakuwa tunaungana na wanahabari wetu kina Steven Leto, Ole Tenges, tutakuwa naye Emmanuel To. Tutakuwa na wanahabari katika kaunti tofauti kutupa hisia zao kutoka kwa wananchi kuhusiana na matukio ya hivi leo. Moja kwa moja, wakili, nianze na wewe, na najua ni mengi yamezungumzwa hasa kuhusiana na mashtaka. Utatupa utaratibu ule wa kuyasoma, manake ni tofauti na ilivyokuwa katika bunge la kitaifa. Lakini kwanza, hisia zako ulipomuona Naibu Rais Rigathi Gachagua ameketi, sio kizimbani, lakini nikana kwamba yuko kizimbani, nikana kwamba yuko mbele ya mahakama. Hisia zako katika mwenendo wake, katika kuketi kwake, kimya chake na kadhalika. Nipe hisia zako za mwanzo.
Hisia zangu ni kwamba Naibu wa Rais anaonekana kusukumwa na kufikisha kwenye ukuta. Anaonekana kunyeshewa. Amekuwa kule mahakamani na kesi 26, lakini hajapata uamuzi wa mahakama ambao unamsaidia. Kwa hivyo ni kama aliyenyeshewa, ni kama pengine anaona ni nyani ambaye miti zote zimeteleza. Sasa ameukalia mti wa mwisho na anaonekana hana matumaini. Unaona kwamba spika wa bunge la Seneti alimuuliza aweze kuketi, sababu yale mashtaka yamesomwa kwa takriban lisali 1 na dakika 30. Akamwambia, Mheshimiwa Naibu Rais, keti kwa sababu itachukua muda. Akasema kwamba hatoketi, atasimama. Na umejua bunge la Seneti sasa
kwa umma inatoa ishara gani, au pale katika bunge la Seneti?
Anaendelea kuchochea hisia za huruma miongoni mwa Wakenya. Kumbuka kwamba huenda naibu wa rais amegundua kwamba bunge la seneti huenda lizimpe usaidizi, kwa sababu yeye anaongea na anafanya kesi na umma. Anataka kwamba hii kesi yake iwe ni kesi baina ya Rais William Ruto na wananchi ambao Rigathi anadai walimchagua kama naibu wa rais. Na najua
tutazungumzia hilo, lakini kwa kiwango fulani pengine amefaulu katika hilo, kuvutia hisia za wananchi, kwa sababu tukipata maoni kutoka kwa wananchi mara kwa mara tangu mchakato huu uanze, utakuta wananchi aidha wanamuunga mkono au pili wanasema asiondoke yeye peke yake, aondoke pamoja na bosi wake.
Hisia za maoni katika taifa la Kenya baada ya Rigathi kuhutubia taifa usiku wa kuamkia siku yake kwenye bunge la taifa, alichochea hisia na kushinda nyoyo za Wakenya na kuzichukua kwamba anadhulumiwa. Alipata muda mwafaka usiku ule kulieleza taifa madai yanayomkabili na lengo la hayo madai, na akaweza kuyajibu. Na alipoenda kwenye bunge la taifa alikuwa anajibu tu maswali, lakini alikuwa amekwisha ongea na taifa. Na leo hii tumemwona akisimama akichukua mbinu mpya, kuonekana mnyonge, kuonekana aliyelemewa, kuonekana anayedhulumiwa,
na kwamba anaweza kustahimili muda wote. Pengine tuzungumzie kwa kifupi tu makundi ya mawakili ambao watawakilisha kesi hii. Unahisi kwamba mashtaka haya ushindi kwa yeyote, iwe ni bunge la kitaifa na upande wa naibu rais, ubabe wa mawakili ndio utakaopelekea ushindi kwa aidha?
Sidhani. Kimahakama na leo bunge la seneti linaketi kama mahakama, ni ushahidi unaoletwa mbele ya mahakama ndio unaopaswa aidha kumfunga ama kumwachilia mshukiwa. Kwa hivyo bunge la seneti lingetekeleza haki kwa kuzingatia ushahidi ulioletwa mbele ya seneti. Lakini kuondolewa kwa naibu wa rais ama hata waziri ni mchakato wa kisiasa. Na mchakato wa kisiasa mara nyingi hauzingatii sheria. Uamuzi wa mchakato wa kisiasa hutegemea mirengo na vigogo wa kisiasa. Hadi kufikia sasa, Rigathi Gachagua anajua ni maseneta wangapi wanamuunga mkono kusalia. Na hao maseneta hawatozingatia ushahidi ulioletwa. Watazingatia uaminifu wao kwake, watazingatia siasa zao na mustakabali wao wa kisiasa.
Amesomewa mashtaka yote 11 na imechukua kama ulivyosema muda wa lisali moja dakika 30. Lakini kabla ya kugusia hilo, kuna hoja ambayo upande wa naibu rais Rigathi Gachagua umezua kuhusiana na wakili James Orengo ambaye ni gavana wa kaunti ya Siaya. Kwa ufafanuzi kama wakili, hatua ya mawakili upande wa naibu rais, kitu gani haswa wanataka kupata uamuzi wa mahakama kumzuia James Orengo kuiwakilisha bunge la kitaifa?
Kwanza, James Orengo ni wakili mtajika, wakili mkuu, senior counsel katika lugha ya Kiingereza. James Orengo ni wakili ambaye amebobea pakubwa na anaheshimiwa na ukongwe kwa sheria ya kikatiba, constitutional lawyer. James Orengo ni wakili ambaye amefanya kesi nyingi za kisiasa. James Orengo ana ufahamu mkubwa, amehudumu kama seneta na anajua kanuni za bunge la seneti. Kwa hivyo anakuja kwenye kundi la mawakili wa bunge la kitaifa na ufahamu mkubwa na ujuzi mkubwa wa kusukuma ajenda ya bunge la taifa. Yule ni wakili ambaye pakubwa anapaswa kuogopwa, na mawakili wa Rigathi Gachagua wameona mwanya wa kisheria ambao unaweza wasaidia kumzuia James Orengo kutohusishwa katika mjadala huu. Na wanasema kwamba sheria haikubali maafisa wa umma washirikishwe kwenye kesi. Na wakasema kwamba James Orengo ni gavana wa Siaya.
Lakini hii itakuwa mara ya kwanza, kwa sababu amewahi kushiriki katika kesi nyinginezo. Hata mahakamani tumemwona akiwa gavana wa kaunti ya Siaya.
Na wakati ule hakuna yule aliyetoa tetezi. Lakini James Orengo alihudumu kama wakili wa gavana wa Busia Sospeter Ojamong wakati ule wa kipindi chake cha pili. Wakazua, wakasema kwamba hapaswi. Tena wakati Jaji Mwilu aliposhikwa na kupelekwa mahakamani, nakumbuka nilikuwa miongoni mwa wakili wa Mwilu na James Orengo. Pia upande wa mashtaka wakasema huyu ni seneta, ako na conflict of interest, hawezi kuwa wakili wa Mwilu. Lakini uamuzi wa mahakama wakatolewa ukasema kwamba maseneta na wabunge wa bunge la taifa ambao ni mawakili wanapaswa kuruhusiwa kuhudumu tajriba ya uwakili kwa sababu sheria haiwazuii. Lakini la leo litakalojadiliwa ni kwamba wakati ule Orengo alikuwa ni seneta na wakati huu Orengo ni gavana. Na ndiposa mawakili wa bunge la taifa walipojibu na kusema hata kwenye kesi ya Mwilu na kesi ya Ojamong, mahakama ilimruhusu Orengo kuhudumu kama wakili. Wakili Ndegwa Njiru alisema kwamba wakati ule mahakama ilimruhusu kwa sababu yeye alikuwa ni seneta wa Siaya. Yeye si gavana, si seneta, sasa ni gavana. Na sheria huenda ikaangazia gavana vitofauti na seneta.
Hatujui uamuzi atakaotoa Spika Amason Kingi wa bunge la Seneti. Uamuzi wote atakaotoa utakuwa na athari katika kesi hii iliyoko mbele?
Utakuwa na athari kubwa. Sitaki kusema uamuzi atakaotoa, lakini Mkenya wa kawaida mwenye akili ya kawaida anajua uamuzi utakaotolewa, lakini hicho pia kitakuwa ni kikwazo. Nakumbuka kile mawakili wa Rigathi Gachagua wanatafuta sasa ni vikwazo vitakavyowasaidia kupata mahakama kusitisha mchakato wote baada ya Rigathi kuondolewa. Hilo litakuwa ni swala mbele ya mahakama kuanzia Ijumaa, kwamba hata wale mawakili waliowakilisha bunge la taifa wengine hawakupaswa kisheria, na Orengo atatajwa.
Tupe mtazamo wa kisheria na kwa sababu ya taaluma ya uwakili, iwapo uamuzi wa Amason Kingi utakuwa kwamba James Orengo asishiriki katika kuwakilisha bunge la kitaifa, hiyo inamaanisha hata kutoa ushauri pia hataruhusiwa ama namna gani?
Kutoa ushauri ataruhusiwa. Kile ambacho hataruhusiwa, jina lake halitowekwa kwenye rekodi ya mawakili na hatopewa nafasi ya kuhutubia bunge la Seneti kama wakili wa bunge la taifa. Lakini upande wa ushauri, kuna washauri wengi sana, na Orengo huenda akawa miongoni mwa washauri iwapo hataruhusiwa kwenda kwenye rekodi na kuhutubia bunge la taifa.
Bila shaka najua toka wiki iliyopita umepata nafasi ya kupitia mashtaka ambayo yanamkabili Naibu Rais Rigathi Gachagua. Leo Jeremiah Nyegenye, karani wa bunge la Seneti, amechukua muda mrefu kuyasoma yale mashtaka. Kwanza tueleze, ni taratibu, ni kanuni za bunge la Seneti kufanya vile? Pili, baadhi ya mashtaka ni kama ambaye yametundikwa kwa kukosa lugha safi, pengine ni kama mgema ambaye anagema mnazi alafu anatundika tembo linajaa mpaka linachacha ndio liweze kutumika, kwa sababu ukisikiza mashtaka mengine ni kwamba ni mambo ambayo alitekeleza miaka 2 iliyopita. Kwa mfano matamshi yake kuhusiana na taifa la Kenya kuwa kampuni ambao washikadau au wenye hisa wanapewa kitu fulani. Sasa mtu atahisi kwani kulikuwa na kisasi cha kukumbusha alifanya masuala yapi miaka 2 iliyopita kiasi cha sisi sasa kuwakilisha ama kuwasilisha mashtaka dhidi yake.
Na ndiposa nilikueleza kwamba mchakato wa kumwondoa afisa wa ngazi ya juu serikalini ni mchakato wa kisiasa. Lakini yale madai yana msingi kwa sababu ni madai yanayosemekana aliyatenda akiwa anahudumu kwenye afisi ya naibu wa rais. Na bunge la Seneti limechukua mwelekeo tofauti na bunge la taifa, kwa sababu bunge la Seneti sasa ndio linaketi kama mahakama na kuchunguza kwa kina madai yanayomkumba Rigathi Gachagua. Nakumbuka linapoketi kama mahakama linapaswa kuzingatia kanuni na sheria za kimahakama. Isipozingatia, mahakama itakapokuwa inachunguza mchakato mzima wataikosoa na Rigathi atarejeshwa.
Tukichukulia mfano wa shtaka hilo tu kwa mfano, maanake tutazungumzia mashtaka mengine. Hilo shtaka la kuzungumzia ubinafsi katika taifa, yani kwamba wale ambao hawakupigia kura serikali ya Kenya Kwanza hawastahili kugawiwa mamlaka, nyadhifa na kadhalika, alivyokuwa akizungumza katika hadhara. Lakini kumbuke kwamba mbele ya macho ya umma Gachagua alikuwa akizungumza saa nyingine hata mbele ya kiongozi wa taifa Rais William Ruto, na mara nyingine usemi wake ulikuwa unaleta ucheshi. Watu wanacheka ni kana kwamba wanakumbatia yale maneno. Sasa inakuwaje leo yanakuwa msingi wa baadhi ya mashtaka ambayo yanakabiliwa nayo?
Kile alichokifanya ama yale madai yanayomkwamba kwamba alisema serikali ni ya wanahisa, yalikuwa ni madai potovu, na wakati ule tulimweleza kupitia runinga hii kwamba ni madai potovu. Lakini wakati ule, kwa sababu siasa za taifa zilikuwa zinaelekea upande wao, wana Kenya Kwanza hawakuona kosa lolote. Sasa hivi kwamba siasa zake haziambatani na zao limekuwa ni kosa kubwa. Wameona kosa leo, kosa ambalo Wakenya waliliona miaka miwili iliyopita. Na Kikwete Jakaya, rais mstaafu wa Tanzania, alisema kwamba anayekutusi hakuchagulii tusi. Sababu ni wakati wake wa kutusiwa. Hawatomchagulia tusi. Watatafuta vijineno na maneno vijisababu ambavyo vinaweza kuwezesha kupeana uzito wa kihoja katika bunge la Seneti.
Naam. Shtaka lingine ambalo anakabiliwa nao ni kumdhalilisha rais ama kwenda kinyume na matakwa ambayo yanatekelezwa na Rais William Ruto katika usemi na hata katika majukumu. Chukulia mfano wa kumwingilia Director General NIS Nurdin Haji wakati wa zogo la Gen Z wakifanya maandamano. Rais William Ruto alikuwa Ikulu wakati akitoa kauli tofauti na nafikiri muda mfupi baada ya mwendo wa saa 11 kuelekea saa 12 Naibu Rais Rigathi Gachagua alikuwa Mombasa akitoa kauli nyingine tofauti kuhusiana na shutuma dhidi ya Nurdin Haji. Kwa nini hawakutoa siri za mapema kuhusiana na zogo ambalo lingetokea kutokana na Gen Z na kadhalika? Tueleze kuhusu shtaka kama hilo.
Mashtaka haya yote katika bunge la Seneti yanapaswa kuwa na ushahidi. Mtu akidai kwamba Rais Ruto alidhalalishwa na naibu wake Rigathi Gachagua, ningekuwa mimi ni wakili wa Rigathi Gachagua kwenye bunge la Seneti, ningeuliza nipewe ushahidi. Nani mlalamishi kwenye hili shtaka? Nani anaelia kuliko mwenye matanga? Je, Rais Ruto atakuja kwenye bunge la Seneti kutoa ushahidi kwamba walimdhalilisha? Shtaka kama hilo la shareholder ni shtaka ambalo ni mbaya sana kwake na ambayo linaenda kumwathiri pakubwa hata kisiasa. Lakini nani anayelalamika? Tunategea kuona ushahidi na mashahidi pengine kuitwa kuelezea ni ushahidi upi walionao kwenye mashtaka walioleta. Na ndiposa umeona wakili wa Rigathi Gachagua Ndegwa Njiru akisema kwamba kuna ushahidi upya ambao unajaribu kuletwa wakati huu, ushahidi ambao hawakuwa nao. Nakumbuka yule ambaye ameshtakiwa ana uhuru wa kikatiba wa kupewa ushahidi utakaozingatiwa kabla ya kikao. Sasa akarai bunge la Seneti lizizingatie ushahidi ule ambao umeletwa nyuma.
Naibu Rais, wakati mchakato huu ukianza katika bunge la kitaifa, wakati akitoa ushahidi na najua uliweza kushuhudia, alitumia video, kanda za video kutoa ushahidi wake. Nyingi ya video zile zilikuwa zinamhusu Rais William Ruto. Kwanza, kama wakili, hilo lilikuwa kosa. Pili, kwa yeye kusisitiza kwa madai mengine. Kwa mfano, swala hili la kumdhalilisha Nurdin Haji, akieleza bayana kwamba sisemi kwamba nilipata ushauri, lakini nilijifunza kutoka kwa rais, wakati pia yeye wakati mmoja akimbeza na kumdhalilisha Inspector General mkuu wa polisi wakati huo katika utawala uliopita. Hilo lilikwenda sawa upande wake ama namna gani? Na unahisi kwamba ataendelea na swala hilo wakati wa kutoa ushahidi hapo kesho ama namna gani?
Rigathi anaelewa kwamba mchakato wa kumtoa ni mchakato wa kisheria na ni mchakato wa kisiasa. Kwa hivyo anapojitetea, anapaswa kujitetea kwa msingi wa sheria na kwa msingi wa siasa. Unapoona anacheza video hivyo na anaruhusiwa kisheria kuleta ushahidi wake, ni kuchochea hisia za kisiasa kwamba sina kosa.
Wakili, zuia hapo, maana swala zuri hilo nataka ulifafanue kwa mapana na marefu, lakini naarifiwa kwamba kwa sasa tuungane na wanahabari wetu kutupa hisia pia. Tuko naye Robert Masai, tuko naye Emmanuel To, na tutakuwa naye pia Marian Nyambura. Wanakusanya maoni kutoka kwa wananchi kuhusiana na matukio katika bunge la Seneti. Naam, tunaanza naye Robert Masai.
Naam, Nimrod, asante sana. Bila shaka tuko katika mji wa Kajiado ambapo wananchi leo kama wenzao kote nchini wamekuwa wakifuatilia shughuli hii tangu ilipoanza asubuhi katika bunge la Seneti. Na hapa sasa nitajiunga nao, kama unaona nyuma yangu wamenizingira. Wamekuwa hapo wakifuatilia kwenye runinga tangu asubuhi na vile kwenye mitandao ya kijamii kuona labda ni nini haswa ambayo inaendelea katika bunge la Seneti. Lakini wanahisia, hamna haja ya kuandikia mate wakati wako hapa. Wacha tujiunge nao moja kwa moja tusikie labda tangu asubuhi Je, bunge la seneti limeweza kuendesha hivyo vikao vipi? Maoni yao ni yapi? Labda tutaanza na wewe, utakaribia tu hapa alafu uanze kwa kujitambulisha, kisha tueleze labda shughuli imekuwa leo kwenye bunge la seneti ya kumbandua naibu wa rais Rigathi Gachagua. Je, kama mwananchi umefuatilia na maoni yako ni yapi?
Kwa kweli Robert, nimefuatilia na nimeona seneti vile inaendelea. Iwapo kama wataweza kuendesha kama bunge ya taifa, inaonekana tayari wananchi hatutakuwa na imani na wao forever, kwa sababu tukianza kusema mheshimiwa Gachagua sijui aliharibu ofisi akajitajirisha, kwanza tunaanzia wale wabunge ambao walijitajirisha pale, the same MPs ni contractors. Sasa kama ni wizi, wote ni wezi na kuva dereva waame wote.
Haya, asante sana. Pia tupate mzee mwingine hapo, unaweza toa kofia kidogo alafu tueleze tu maoni yako kuhusiana na vikao vya bunge la seneti leo. Imeanza mchakato ya kumtimua naibu wa rais Rigathi Gachagua.
Mimi kwa upande wangu nimeona vile wanaendelea vizuri, lakini hatujui ya mwisho vile watakapofanya. Lakini kwa vizuri kama vile wabunge walipofanya, wakiona ni vizuri kumbandua ni sawa, wakiona atambakisha ni sawa, lakini kitu ya maana tunataka amani nchi ya Kenya. Na tena waangaliwe, kwa sababu kama hao ni wafisadi itakuwaje hata yeye naye ni mfisadi. Kwa hivyo waangaliwe wote na wachunguze bunge yote ili tuone kama hiyo mambo itakuwa mzuri.
Naam, karibia tu hapa hivi alafu tueleze, labda umekuwa ukifuatilia vikao tangu asubuhi. Je, umependezwa na namna bunge la seneti linaendesha vikao vyake, na labda unatarajia nini kutokana na hivi vikao?
Kwa majina ni Edi Gashao. Venye imeendelea sijafurahia, lakini venye itakuwa uko mbele wacha tuweke tu imani, lakini mlima isiguzwe. Na kama ni kufa dereva, kufa makanga. Asante.
Haya, pia tupate mzee, karibia tu hapa alafu tupe maoni yako kuhusiana na vikao vya seneti na mchakato mzima wa kumbandua naibu wa rais Rigathi Gachagua.
Gachagua must go. Aende sisumbue na wananchi.
Sauti.
Sisumbue na wananchi, aende nyumbani.
Haya, asante sana. Pia tupate mwingine, kama unaweza karibia tu hapa mzee, alafu tueleze vikao vimeanza leo na tunatarajia kwamba vitakamilika hapo kesho. Je, umekuwa ukifuatilia?
Kwani nauliza kitu moja. Nyinyi ulikuja hapa kwa kasi ya wenyewe.
Naam.
Nyinyi ulipangaje ile kasi hii?
Haya, asante.
Kasi yenu kabla wenyewe hakuna ripoti akuletewa. Mimi hakuna mtu mbaya kama Gachagua. Kama mtu akishindwa kushika jirani wala kwako ule nyumbani kama yeye na Ruto, ni wewe ndio mjinga ya mwisho.
Sawa, asante sana. Ni maoni ya wananchi kutoka hapa kaunti ya Kajiado ambao wamekuwa wakifuatilia hivi vikao tangu asubuhi, lakini tunazidi tu kuendelea kutazama moja na wao, alafu baadaye tutakuwa nazungumza zaidi, lakini kwa sasa na kupeleka hadi bunge la seneti ambapo mwenzangu Emmanuel To yuko pale. Wamekuwa pia wakifuatilia vile vikao. To, kama unanipata basi kazi kwako.
Naam, asante sana Masai. Tunakujia moja kwa moja kutoka katika majengo ya bunge hapa katika lango kuu la bunge la seneti, ambapo tunatarajia kwamba kwa muda wa dakika 50 hivi zijazo tutakuwa tunamuona spika wa bunge la seneti Amason Jeffa Kingi akitoa uamuzi kuhusiana na yale malalamishi yaliyoibuliwa na upande wa Gachagua, wakisema kwamba gavana wa Siaya kwa sasa James Orengo hafai kuwa kwenye kikosi cha mawakili wakilisha bunge la kitaifa. Kumbuka kwamba kumekuwa na madai kwamba sasa yule gavana hana ile nafasi ya kuwa na ile hali ya kusema ama kutoa uamuzi wake bila kuegemea upande wowote, kwa sababu ni gavana kwa sasa. Lakini tunatarajia kwamba spika Kingi atakuwa anatoa maelekezo kuhusiana na wasilisho hilo. Kumbuka kwamba kuna pia mawakili wengine wengi ambao wako kwenye orodha ile ya kumwakilisha ama kuwakilisha bunge la taifa, ambao pia ikiwa gavana Orengo ataondolewa kwenye kikosi, kuna wengi zaidi ambao watachukua nafasi ile na watakuwa wanacheza ngoma ile kulingana na mpangilio wa bunge la taifa, wakiwemo Paul Nyamodi ambaye pia ni wakili ambaye alitarajiwa kuwa kiongozi mkuu, Eric Gumbo, Kipkogei, Moses Kipkemoi, Mudhomi Thiankolu, Peter Wanyama, Meli Kennedy Kipkoech, Joan Jeruto, Murioki Eric Mweregi, Mwereru Boniface Mawera, Ondago Kevin Otieno, Alex Mbaya, Kennedy Chalo na John Mwangi Kangu. Kumaanisha ni kikosi cha mawakili 14 ambao wako upande ule wa bunge la kitaifa ambao wanaweza chukua nafasi ya Orengo ikiwa atondolewa, na pia kama atasalia kikosi kitasalia vile vile kabla ya ngoma kuanza mwendo wa saa 8:30. Kumbuka pia kuna mawakili ama mashahidi ambao tunatarajia kwamba watakuwa wanachukua nafasi kutetea upande wa bunge la kitaifa, wakiwemo katibu katika baraza la mawaziri Masi Wanjau, tunaye pia gavana wa Nairobi Johnson Sakaja, kuna aliyekuwa afisa mkuu mtendaji wa mamlaka ya kukadiria ubora wa bidhaa KEBS Andrew Mulwa, pamoja na mwanabiashara mashuhuri ambaye ameingia kwenye orodha hiyo hapo jana ambaye ni Peterson Njomo Mushira, ambao wote wanatarajiwa kuchukua nafasi ile na kuchukua katika muda wa kutoka saa 8:30 watakuwa wanatoa ushahidi wao kuhakikisha kwamba ule ushahidi ambao umetolewa na bunge la kitaifa unasimama wakati ambapo shughuli itakapokuwa inang'oa nanga. Kumbuka pia ni kwamba kuna upande ule wa Gachagua pia utakuwa unapata nafasi ya kuuliza maswali hao mashahidi, wakitarajiwa kueleza tu kama kuchunguza na kujua kama ushahidi ambao wanatoa ni wa ukweli ama si wa ukweli, na shughuli inatarajiwa kwenda hadi mwendo wa usiku hivi kwa sababu vikao vya bunge vilichelewa kwa muda wa saa 1:30 hivi kabla ya kung'oa nanga mwendo wa saa 5:30. Kwa hivyo kuna mengi ambayo tunatarajia hapa katika bunge la Seneti wakati ambapo vikao hivyo vinashika moto. Kesho itakuwa ni siku ya ndovu kumla mwanawe, wakati ambapo Gachagua atakuwa anafika kwenye bunge hilo kujitetea rasmi. Kumbuka ni yeye peke yake ndiye shahidi wake mwenyewe kwenye kesi hii, na atakuwa na muda wa saa 4 kujitetea ama saa 3 kujitetea na saa 2 za kuulizwa maswali na wale mawakili. Kumaanisha ni shughuli pevu hapa, na tunajua kwamba itakuwa inaenda hadi mwendo wa usiku. Kwa hivyo ni hayo tu kwa sasa, na kupeleka moja kwa moja hadi kaunti ya Nakuru kwake Miriam Nyambura aweze kutueleza wakazi wa Nakuru wanasema vipi.
Naam, shukrani Emmanuel to kwa taarifa hiyo ya kina kuhusiana na yanayojiri katika Seneti. Na hapa katika kaunti ya Nakuru nitakuwa na baadhi ya wakazi ambao wamekuwa kifuatilia mchakato huu wa kumbandua Naibu Rais Rigathi Gachagua afisini, na vile vile tu nitakuwa nikizungumza na baadhi yao watueleze ni nini haswa ambayo wameona kufikia sasa. Nikianza nawe, pengine uweze kutueleza kuhusiana na tumeona hii leo Naibu Rais Rigathi Gachagua ameweza kusomewa mashtaka hayo 11 na akakana kunradhi. Pengine tueleze kwa maoni yako, unadhani kuwa mchakato huu unaendelea vipi kufikia sasa?
Asante sana. Kwa majina naitwa Simon Sangale Olenasieku, mkaaji wa Nakuru. Yale mambo yamekuwa kiendelea kuanzia kule kwa National Assembly na siku ya leo Senate. Mimi ningependa kusema ni kwamba ijapokuwa Rigathi Gachagua amesimama kidete kama mwanaume kufa kimwanaume, lakini jambo ambalo inajitokeza waziwazi ni kwamba hii ni kama mahakama ya chui ambayo inasimamia kondoo, na sioni jinsi ambavyo Rigathi Gachagua atafanikiwa katika Seneti. Tukiangalia yale mambo yalianza kuanzia mwanzo hapo katika mji wa Nakuru, mimi nikiwa mji wa Nakuru, tuliona vile ambavyo public participation, watu walikuwa naitwa na mbunge katika hoteli yake, wengine katika mapetrol station, wanaandikishwa mafomu kama siku 2 usiku na mchana, wakitolea majina kutoka kwa mafomu za basari. Mimi naona kwamba Rigathi Gachagua mahali imefika, mahali ambapo tu peke yake unaweza ponea ni ikiwa kwamba mahakama za Kenya zitaweza kukupatia nafasi ya kukusikiza siku ya Ijumaa. Lakini vile mambo inapelekwa mbio kwa sababu tunaangalia hivi. Ukiangalia mpaka siku ya leo tunaona kwamba yule ambaye ni governor wa Murang'a Irungu Kang'ata tayari ametembelea Raila Odinga. Na ukiona mahali ambapo Raila Odinga anasalamiana na mtu uje kuna mambo fulani yanapangwa. Tumeona katika katika kaunti ya Kirinyaga, wengine wameanza kutaja pia katika yule anaitwa Waiguru. Hapa mjini Nakuru tumeona wengine wameanza kufanyia Senator Susan Kihika campaign. Mimi ningependa kumwambia senator wetu ambaye ni Tabitha Karanja, tafadhali sikia sauti ya ground. Unaona jinsi ambavyo wabunge waliweka yes, na vile ambavyo nyumbani kwao katika mlima wa Kenya na Nakuru wamejificha. Wewe pia kama senator wa Nakuru County. Ikiwa utaweka yes, ujue kwamba pia wewe itabidi uhame katika mji wa Nakuru.
Shukran. Acha nipate maoni ya wakazi wengine. Tueleze kuhusiana na mchakato huu ambao unaendelea kwa sasa, ama umesitishwa kwa muda, na utarejea baadaye. Pengine tueleze, umekuwa ukifuatilia mchakato huu, pengine maoni yako ni gani kama mkazi?
Kwa majina ni Brian, niko hapa mjini Nakuru. Ningependa kusema kulingana na mchakato ambao unaendelea wa kumbandua our Deputy President Rigathi Gachagua na kufikia mahali ambapo umefikia huko Senate, ameshasomewa mashtaka yake ama ameshasomewa zile tuhuma ambazo wanataka kumbandua katika mamlaka nazo, na tumeona ameweza kukataa zote ya kwamba si mambo ni mambo anaekelewa, si mambo ambayo ni ya ukweli. Kile tunangojea kutoka pale ni haki ikaweza kutendeka, sababu kutoka pale mwanzo tunaweza sema ni kwamba ni mambo imezingatiwa ama imesukumwa na msukumo wa kisiasa, sababu kuanzia mwanzo pale parliament tuliona alifanya public participation, na kulingana na katiba article 1 inasema sovereign power belongs to the people, na the people of Kenya were not given opportunity kwa ukamilifu ama vile ilifaa tukaweza kutoa maoni sisi wote kwa muda ambao ulifaa. What we saw ni kwamba walichukua muda kidogo, na bad girl akipeana ripoti pale kwa parliament, anajiita bad girl, akipeana ripoti pale kwa parliament siku yenye walikuwa wanafanya huyo mjadala, alionyesha ya kwamba watu 1189 ndio waliweza kupiga ama kusupport motion ya aweze kubanduliwa. Out of more than 47 million Kenyans, only 1,189,000 ndio walitoa maoni ya kwamba ati aweze kubanduliwa. Where are the rest? Sauti yetu ilipatikana wapi? Tukuletewa hiyo jambo hata katika grassroots, pale ambapo tunapigia kura katika polling stations. Kitu ya kwanza naweza public participation haikufanywa kwa ile njia ambayo tulitarajia, na ile tunangojea pale kwa Senate. Tunangojea haki iweze kutendeka, mashtaka iendelee. Tumeona hako na legal counsel ambayo ametembea nayo mahala pale, hako na watu ambao wako na tajriba, lakini tunangojea kutoka kwa senators waweze kufanya haki, lakini mwananchi bado anategemea kwamba kukue na amani. Tunaomba amani ikue, hata kile ambacho kitatendeka kikue, sababu nguvu zenye ziko pale kwa Senate ama uwezo wako nao wa kuweza kumtoa ama kumweka remain pale, since tumeona hajapata, ana tumaini kwa koti ya kwamba koti ilisimamisha, haikuweza kusimamisha maendeleo ama impeachment isiendelee. So hatuna tumaini kwa koti sana, tunangojea pale kwa Senate ile itatendeka itendeke, lakini tunaomba amani. Kama Rigathi ataenda ama atabaki, amani ikue. That's what we pray for.
Naam, shukran. Haya, shukran kwa maoni hayo. Nipate sauti nyingine kama mkazi na mfanyabiashara hapa katika kaunti ya Nakuru. Umekuwa ukifuatilia swala hili kwa kina, pengine tuambie maoni yako ni gani kuhusiana na mchakato huu ambao unaendelea kwenye bunge la Senate?
Mwanzo ni kusikitisha sana jambo hili ama kesi hii ambayo uko kwa Senate wakati huu, kwa sababu vile mambo imechukuliwa kuhusu huyu makamu wa rais ama deputy president ni kwamba limechukuliwa kirahisi sana. Hili jambo limekimbia. Hata angekuwa mzee wa nyumba 10, nafikiria awe na kesi fulani, nafikiria hii kesi haingekuwa imefika mahali ambapo kiwango kutoka kwa bunge la kitaifa hadi kwa bunge la Senate hadi imeingia mahakamani tena, haingekuwa imefika hapo. Lingekuwa ni jambo lingekuwa linachunguzwa, lakini anapojaribu hata kusema ukweli wake ni kama jambo hili lina msukumo, na ningetaka kusema mkono wa Samoei ni kama uko hapa ndani, na huyu Rigathi ndiye alimsaidia katika kupata huu urais, na ndio maana juzi wananchi hapa ground walikuwa wanasema kufa dereva kufa makanga, wote waende, sababu hata yeye si mzuri, hakuwa mtu mzuri, hakuwa mzuri, si ati ni mzuri. Hata saa hizi furugu anaongoza yeye mwenyewe zitamrudia, kwa sababu hapa ground wananchi wataendelea kuona kama ni ukabila, ni kama kabila hizi zingine zinainukia Wakikuyu, sababu saa zile unasema Raila utamweka deputy, na yeye alikuwa Azimio, hata wengine wetu tulikuwa Azimio, tulipigia hiyo Azimio, na sasa umeleta watu wa Azimio katika hilo jambo. Hao ndio sasa wanaamulia Gachagua kesi yao, ndio wanapiga kura ati Gachagua atolewe, na hawakumsaidia pale mwanzo. Wewe Samuel ni unaongoza watu katika chaos, na inakaa ni kama haupendi amani na haupendi watu wakae na amani hali ulipo.
Asante. Naam, kama ulivyosikia ni maoni ya wakazi hapa katika kaunti ya Nakuru kuhusiana na mchakato huu. Tutazidi tu kusubiri kujua hatma ya Naibu Rais Rigathi Gachagua, wengi wao wakisema watazidi kufuatilia, lakini swala kuu ni kuwa amani idumu. Kwa sasa tuelekee katika kaunti ya Kisumu ambapo mwenzangu Laura Otieno yuko na baadhi ya wakazi watueleze mengi zaidi kuhusiana na mchakato huu wa kumbandua afisini Naibu Rais Rigathi Gachagua. Laura Otieno, kwako.
Na shukrani sana Marian. Na hapa katika kaunti ya Kisumu pia wakazi wanahisia mseto kuhusiana na kikao cha seneti ambalo linajadili hoja la kumng'atua afisini Naibu Rais Rigathi Gachagua. Baadhi yao wanasema kuwa pengine ni haki iwapo Rigathi Gachagua ataondolewa, lakini kuna wale ambao wanasema kuwa hana makosa ama yale mashtaka ambayo yamesomwa juu yake hayana idhibati ya kutosha. Basi tuzungumze nao moja kwa moja. Anza kwa jina na uniambie, kwa ukiangalia vikao vya seneti hii leo kama Mkenya, wewe unaona haki itachukua mkondo gani?
Haki, mimi naongea kama Sheila, mkaaji wa Kisumu. Mimi naonelea ya kwamba kuondoa Gachagua kama hawa msimamizi wetu wa MPs walifanya makosa kuweka meeting usiku. Kama mtu ako na makosa, achajiwe ama waongee kwa hiyo makosa yake mchana. Na kama ni maoni ya MPs, mbona wakuchukua maoni yetu kwanza, waone sisi pia tujadiliane nao kwa akili moja, mambo moja, tujadiliane maneno moja. Makosa ya Gachagua hakuna hata moja. Awachiliwe aendelee na kazi yake.
Lakini kulikuwa na ule mchakato wa public participation ambao ilikuwa hapa Kisumu ilikuwa inafanyika katika uga wa Tom Mboya. Pengine wewe hukushughulika na hilo, manake pale ndio Wakenya walikuwa wanatarajiwa kutoa maoni yao. Hukushughulika na hilo?
Mimi nilishughulika penye nilikuwa. Tulikuwa Kasagam kwa meeting nyingine, nikapewa form nyingine, niliona mtu kama anatembea nayo. Na hii form iliandikwa, nilisoma pande ya kwanza, pande ya nyuma. Nikaona awachiliwe aende na kasi yake. Mimi nilisema hapana, asiondolewe, akae tu kazi yake. Tutaona kama atafanya kazi mzuri. Na yeye pia Gachagua mwenyewe, deputy president, yeye ni mtu mkubwa. Amesasomewa makosa yake, anajua kiroho. Hapa alifanya makosa, hapa hakufanya makosa. Atachajiwa tu venye yako, but mimi naonelea ya kwamba makosa yake amsamehe. Kama kuna maneno kati yake na rafiki yake mwenye alimleta, sisi na hatukumpigia kura, tulipigia president kura, lakini si Gachagua. Gachagua, President Ruto ndiye alienda akarokota huko, akakuwa rafiki yake. Sasa wakitengana hao wawili, kama bibi na bwana wanatengana na wanatengeneza. Waende watengeneze wawili, mimi nawaombea kama Sheila, mkaaji wa Kisumu, asamewe.
Sawa. Asante sana. Anza pia kwa jina na utuambie leo Naibu Rais Rigathi Gachagua yuko katika bunge la Seneti. Amesomewa hayo mashtaka 11 na amekana yote. Wewe kama mkazi wa Kisumu unaona haki inafaa kuchukua mkondo gani?
Okay, mimi kama jina naitwa Linet, mkaaji wa Kisumu. Mimi kama maoni yangu naona hakuna haja watoe Gachagua. Kwa ajili already hao watu walikuwa wanafanya kazi pamoja. Na vile naona Senate huwa iko na haki. Senate wanajua kazi yao yenye wanafanya pale. Na najua lazima watapata haki. Na najua kitu mzuri Gachagua hatabaki. Kwa ajili kila mtu hapo ndani, Ruto ako na makosa mingi sana. Gachagua ako na makosa mingi sana. Hao watu wote niseme hao nini wenye wako kwa serikali wote wako na makosa. Sasa tukianza kuweka hizo makosa moja moja zitakuwa mingi sana. Sasa mimi naona heri Gachagua baki tu na wamalizane na hii term. Next aone vile anafanya. Sioni haja watoe Gachagua.
Naam, shukrani sana. Pia kuna mkazi mwingine hapa. Pengine wewe unaona haki itachukua mkondo gani? Maana kuna wale wanasema kuwa mchakato huu ni wa kisiasa, wengine wanasema kuwa kuna makosa lakini wasamehewe. Wewe anza kwa jina na unaambie unaona haki inafaa kuchukua mkondo gani?
Kwa jina naitwa Priska Nyango, mimi ni mkaaji wa Kisumu. Kile naweza sema kuhusu Gachagua ni kitu moja. Hiyo venye wameamua ati Gachagua aende nyumbani, Gachagua siende nyumbani. Kwa vile unaona nyumba inajengwa na watu wawili. Nyumba tulishajenga. Sasa kwa nini mwenzake anataka kubomoa? Nini anaona hapo ndani yenye hataki Gachagua ajue? Tafadhali wawachane na Gachagua aendelee na kazi yake, amalize kazi yake pamoja na Ruto. Waendelee na kazi yao pamoja. Na kama wanataka kutoka, watoke wote. Juzi sisi jenzi tulikuwa tunataka kutoa Ruto. Baba akakuja akaongea akabaki. Na sasa kwa nini yeye anataka kutoa Gachagua? pia yeye aende na Gachagua kama anataka kuenda. Na Gachagua abaki afanye kazi. Ni kijana wa mtu vile Ruto ni kijana wa mtu. Gachagua aendelee na kazi.
Naam. Shukrani sana. Kama ulivyosikia basi ni mradi kwamba wanasema iendelee. Naona mama amebanwa sana. Kwa kifupi tu, anza kwa jina na utueleze kwa mtazamo wako, haki inafaa kuchukua mkondo gani?
Kisa na maana, kabla tujaanza kusema nitakana tuongee, mimi naitwa Elizabeth Halush. Na ukweli nayo ni kwamba kilicho na mwanzo lazima kiwe na nini? Na mwisho. Sasa imetuma sisi pia masikio yetu imefanya nini? Imeteguka kwa sababu kuna siri hatukuwa tumejua, lakini kwa wakati huu tumefinywa mpaka tukakereka.
Kwa hivyo wewe unaona mkondo haki unafaa kuchukua mkondo gani?
Jambo la busara, jambo la kwanza, ukweli hatukatai. Liwe liwalo walikuwa kule, hatukatai. Lakini la pili, lazima pia watuangalie sisi huku hivi nje penye tuko. Lazima watuangalie na masikio, lazima ifinywe pia. Walifinyika wenyewe na sasa imetibuka. Sasa tufanye nini? Sasa tuambie ukweli yetu kule iko.
Ni kama ulivyosikia ni kwamba wamesema masikio na yasikie ili haki itendeke. Basi
yule mzee amejua siri ya pale kwa ile gwaride.
Naam, shukrani sana. Kama ulivyosikia basi tuchukue mapumziko mafupi hapa katika Sema na Citizen, kisha tutarejea zaidi na maoni kwa wananchi kuhusiana na hoja nzima la kumng'atua afisini Naibu Rais Rigathi Gachagua.
Whether you're shopping in-store or relaxing at home, Carrefour Kenya makes it all easier. Introducing the Carrefour app, your all-in-one shopping solution. Whether you're at home or on the move, explore a wide range of products, discover exclusive deals, earn loyalty points, and choose a delivery option that works for you. Need your order fast? Choose Express Delivery and get your items within 60 to 90 minutes. Or go with scheduled delivery for convenient scheduled time. Checkout is fast and secure, and you can pay using M-Pesa, card, or loyalty point. Enjoy the best offers, earn rewards, and shop securely. Whether you choose in-store shopping or delivery with the Carrefour app. Download the Carrefour app today and enjoy all the benefits of a smarter, easier way to shop.
Hi, I'm Miriam.
Expressions that extend to propaganda for war, incitement to violence, hate speech, advocacy of hatred, that cannot be protected speech. Now, the other very important point which I want to put before the Senate, sometime in February 2017, the Deputy President traveled to London, and he went to a hospital in London where his brother was admitted in ICU. When he arrived the next day, he prevailed upon his brother to execute a will. That was on the 17th of February, 2017. In that trip, there is no evidence at all that he tried to talk to doctors or physicians who are looking after his own brother. After this visit, he walked away. And 7 days later...
Mr. Speaker, I rise to raise an objection.
Can I proceed?
Mr. Speaker, we owe the Deputy President very elementary decency. We owe it to the Deputy President to be basically decent in these proceedings. I want to know whether counsel at the bar, one, can adduce this kind of evidence that is not contained in any evidentiary material before the Senate. I want to know which ground in the 11 grounds in the impeachment motion is this evidence from the bar supporting. I repeat, Mr. Speaker, we owe the Deputy President the most basic decency. I object.
Senior Counsel Orengo, those amendments, are they contained?
They are contained, they are all here.
And refer to the document.
Volume 4. I am not referring because if I've got to refer to every document, will take a lot of time, and I have only 30 minutes. If you look at volume 4 of this document on public participation, from page
Volume 4 of the National Assembly.
Of the National Assembly.
Pages
114 to. In fact, it is the Deputy President who has also relied on that will. It's also part of his defense. Yes, and in fact, this page is also called "Tend the Will," and the Deputy President is the one who is relying on this will. The death certificate is contained on page 119. And it shows the only person who attended the deceased, the brother of the Deputy President at that time, was his daughter, was the only person present. And then there's the will, and in the documents on page 128, and this is why I was raising this matter, on page 128 there's a letter by Mr. Madenge and Mr. Njoroge Rigeru, who together with Mr. Rigathi Gachagua were the joint will executors. And they are complaining about the conduct and action of the Deputy President as an executor of the will and a family member of the late Nderitu Gachagua. On page 129, paragraph 8, there, and it says, from bank statements to this, for this account seen by us, you transferred some funds from these accounts to other persons as follows. On the date when Nderitu Gachagua died on the 24th, the Deputy President was already withdrawing money. On the day he died, and that day when he died, he was there only with his daughter. And then they say on the 19th of May 2017, again another money was withdrawn and paid to Mrs. Wamunyuro Investment Limited. This story, you will find it in the documentation. And part of it is what Mr. Njomo was saying.
Counsel for Deputy President, just have your seat. When your time comes, you'll be able to make the rebuttals. Proceed, Senior Counsel.
How many minutes do I have?
Mr. Speaker, I respect your direction. I'm willing to take a seat right away, but just to point out something. The document you are being referred to is the document you held in abeyance. Because it was given to us later for purposes of our consideration. That's number one. Number two, Mr. Speaker, you remember that my learned colleague talked about how my client traveled to London, how without talking to any doctor. These are factual claims, Mr. Speaker, that are just coming from the bar. Mr. Speaker, number three, the opening statement speaks to the motion and the grounds in the motion. I beseech this House direct that parties restrict themselves to the motion and the grounds in the motion. The facts you are now being referred to have no basis in the motion and the grounds in the motion, unless Senior Counsel, His Excellency Governor Orengo, can draw your attention to any ground in the motion that those facts are not addressing. I repeat what I said earlier, Mr. Speaker. The ruling is yours. We owe it to the Deputy President and the integrity of our check and balances institutions to maintain basic decency in these proceedings. I rest.
In fact,
Council, I cannot tell you how you're going to make your opening statements. If you're going outside the allegations, that's up to you. The senators are here listening, and they'll be able to make the necessary decision at the end of this. Now, Senior Counsel Orengo, there's an environment that you've made that the Deputy President of the Republic of Kenya, on a certain date that you indicated, traveled to London.
Yes. The evidence is
his sick brother.
Yes.
And on the side of the sick bed, he made his brother sign a will. Is that contained anywhere in the documents from the National Assembly?
My Lord, Mr. Speaker, if you look at volume 4 from the pages that I indicated, right from page 113, it shows what flight he took, at what time, a British Airways flight on the 16th, and arrived in London on the 17th. The only business that comes out from that document and his documents is that he got a will signed, and there is no further evidence of his activities in London until 24th, when the only activity in which he didn't participate was to be present when his brother died in London. But all this I'm saying in relation to the allegations that we have against the Deputy President.
Mr. Speaker, sir.
Counsel, ordinarily, no objections are raised during the 30 minutes of the opening statement. Ordinarily. I have tried to accommodate, but now you're stretching my generosity a bit too far. Allow Senior Counsel Orengo to conclude. In your opening statement, you may choose to make a rejoinder.
What I want to conclude is this. From what I've said, from the way his brother's account were raided, that was continued to the time when All Life Guidance was acquired for a sale by proxy of 412 million shillings. He bought property in Nyeri, the outspan and treetops for an amount exceeding 800 million shillings. And we're saying part of that money was not money coming from him, and evidence will show that he was raiding monies that truly belonged to the estate of his late brother to acquire property. If that is not an offense by law, these were proceeds of crime committed by the Deputy President to acquire property. And to drive this point home, the judgment by Justice Minor, which is also part of the record, where she made a determination, and that judgment stands, that the 200 million shillings that was found in an account with a financial institution in excess of 200 million shillings were proceeds of crime. And that 200 million shillings, again, the documentation here, if you look at it and we show it in evidence, was the same money that was used to acquire treetops and Aberdares as part of the money that his sons were able to use to acquire those properties. So we are saying that the acquisition of these properties what came out of criminal conduct. And all the particulars of the criminal conduct is found in the documents that were presented before the Senate. Now, Mr. Speaker, I think that it is critical that we look at the authority of the office of the Deputy President vis-a-vis that of the President, the doctrine of collective responsibility. And I showed why the office of the Deputy President is so important in carrying certain functions so long as he lives to the true spirit of the Constitution. Many times, and the incidents have been shown, acts of insubordination, like when he issued a press statement in Mombasa after the President himself had issued a statement that went contrary, absolute insubordination to the President, who is his boss. And if really one can talk about insubordination, that was an act of insubordination. Lastly, the other issue that I need to bring out quickly is that the Constitution and the Senate is aware of the fact that at the end of, at every 5 years, you pass a basis for allocation of resources here in the Senate. And they abide by certain principles which are contained in Article 203 of the Constitution. This issue about certain areas being preferred because they're shareholders goes against the very spirit of the Constitution. Or the notion that people can be appointed into government on the basis of how they voted or on the basis that they are shareholders, that is not again borne by the Constitution, because the executive authority that is granted to the executive requires that even in allocation of revenue and appointment of people to serve in the public service must depend on regional balance. So to talk about shareholders, to talk about some people being able to reap on the basis of shareholding, that is repugnant and in conflict with the provisions in our Constitution. Now, Mr. Speaker, I would want to say this with all the seriousness it deserves. This Constitution is supposed to work. It's supposed to work. And it can only work if state officers are compliant with the provisions of the Constitution.
2 minutes to wind up.
Yeah. Well, if they're compliant with the provisions of the Constitution. The doctrine of collective responsibility and the authority of members of the cabinet spring from the fact that they are all individually and collectively responsible to the President. If that primary principle cannot be applied, then it will be difficult for any government elected to function in a manner that it can deliver services to the people of the Republic of Kenya. So I urge this Honorable Senate that having painted that large picture, the next phase, when you are now going to listen to the evidence and look at the exhibits that we have attached, you will find that a strong case has been made out for the impeachment and removal from office of the Deputy President of the Republic of Kenya. And this Senate should not shy away from undertaking that responsibility. It does not matter that there is a matter that could be taken to DCI or to the AACC. The role of Senate is different to undertake oversight over those who are given a responsibility to manage the affairs of the country. And that does not depend on the role of any other agency or body created by the Constitution. Your role is to demonstrate to all people in state offices that this oversight role that you play, whether it is that of impeachment, to demonstrate to the people of Kenya that it is not cosmetic. And where there's evidence, like the evidence that we are showing and adducing before you, that person,
I'm afraid, Senior Counsel, your time is up.
Should suffer the consequence. I thank you. I thank you.
Counsel for the Deputy President. Floor is yours.
Thank you, Mr. Speaker, sir, and thank you, distinguished senators. My name is Elisha Ongoya. I stand here to make the Deputy President's opening statement. Allow me, Mr. Speaker, sir, distinguished senators, to open by reminding us some fundamental principles. We are sitting here today as a Senate to discharge a constitutional mandate. And before you are given the cudgels to start discharging any mandate in this Senate, the Constitution demanded that you had to take an oath of office before you do anything else. I now understand better why that oath of office was prescribed and why it was framed the way it was framed. The Deputy President reminds you the following terms in your oath of office before you assumed office to discharge the functions of senators. You have to bear true faith, and allegiance to the people and the Republic of Kenya. You have to obey, respect, uphold, preserve, protect, and defend the Constitution of Kenya. And you have to faithfully and conscientiously discharge your duties as members of the Senate. I submit respectfully that the case regarding the proposal to remove the Deputy President from office by impeachment may appear to put the Deputy President on trial, but that is only in the most technical sense of this process. At a more significant level, what is on trial throughout these proceedings is the resilience and steadfastness of our Constitution, our constitutional institutions of checks and balances, and actually their capacity to withstand any form of waves and pressures. That is what is truly on trial. His Excellency Rigathi Gachagua beseeches this House to keep in mind that we have a constitution, a constitutional order, and a constitutional democracy to protect as we conduct these proceedings and as we make decisions in these proceedings. He asks you that at the end of this exercise, let our constitution, our constitutional democracy, and our constitutional order emerge stronger. Allow me to address this House on the defined standard for impeachment of the Deputy President. In a comparable decision by the Supreme Court of Kenya, the case of Honorable Mike Mbuvi Sonko versus the Clerk, County Assembly of Nairobi and others, the Supreme Court observed as follows, and I quote, "It must, however, be stressed for the avoidance of doubt that the power of impeachment, removal, or recall is not one expected to be in constant or frequent exercise. It is only in the face of credible evidence of extraordinary wrongdoing, that the conduct of a state officer will be investigated, and even then, only upon sufficient proof of the allegations that the impeachment, removal, or recall would be warranted. Two questions we pose must constantly linger in your minds, distinguished senators, as you undertake the assignment now before you. Question number one, we beseech you to bear in mind the question, is there credible evidence of extraordinary wrongdoing on the part of His Excellency Honorable Rigathi Gachagua before you? Number two, is there sufficient proof of the allegations leveled against His Excellency Rigathi Gachagua? Article 150, Clause 1, Paragraph B, sets out the grounds for removal of a deputy president from office by impeachment. These grounds are, number one, gross violation of the Constitution or any other law. We emphasize the drafter's use of the word gross. Serious reasons to believe that the deputy president has committed a crime under national or international law. Again, we emphasize the word serious, then gross misconduct. Surmises, conjecture, street rumors cannot pass muster. This conduct must be the conduct of the person of the deputy president. It is sufficiently notorious for this court to take judicial notice of when the late Nderitu Gachagua, whose will is now referred to here, died. You are told to investigate the conduct of His Excellency Rigathi Gachagua at a time, or at the time around which his brother, His Excellency Governor Nderitu Gachagua, as he then was, died. It is sufficiently notorious that His Excellency Rigathi Gachagua was not Deputy President of the Republic of Kenya. But that's not enough. You will peruse the motion before you with a view to finding which ground in that motion is sought to be established by these allegations around what may or may not have happened around the time the late Nderitu Gachagua died. You will find absolutely no ground supported by those allegations. Let me disclose here. It is designed to whip your emotions. It has no other purpose. Looking at your oath of office that I've alluded to, there is no room for your emotions to be whipped as the basis of decision-making in any act that you engage into in the discharge of your constitutional mandate and responsibilities. What does our Constitution expect of the mover of the motion in proceedings of this nature? Our Constitution expects the mover of the motion to make allegations of any or all the grounds set out in Article 150, Clause 1, Paragraph B of the Constitution. And we begin by submitting it is true that the mover of this motion has written down some allegations in Volume 1 of the documents from the National Assembly. Secondly, the mover of the motion is thereafter expected to supply credible evidence of an extraordinary wrongdoing and sufficient proof of the allegations against the Deputy President. Mr. Speaker, sir, distinguished senators, we submit that is where the mover of this motion ought to start having problems with this House when he's called upon to account. It is the submission of His Excellency Rigathi Gachagua, that the motion now before you has fallen short of the threshold set by law by multiple miles. When you examine the material before you, you will discover that it will oscillate between the following categories of stages. One, you will have material before you that just plainly false. Then from falsehood, it will go to the ridiculous ones, and I'll demonstrate that shortly. There will be ridiculous claims here. Then finally, it will end up into embarrassing claims. Allow me, in the few minutes I have, to just do a sneak preview of some of these claims so that we have an overview of the case that is before you. At paragraph 74B of the first volume, which is the impeachment motion, you will find an allegation of this nature, that His Excellency Rigathi Gachagua has influenced his family members, allies, associates, and proxies to take control of a local cooperative society in Madira, which they are financially hemorrhaging. Number one, no name of any family member is supplied in the allegation or in any of the evidentiary documents before you. No name of any ally is supplied in the motion or in any of the documents before you. No name of any associate is supplied, even a false name, none, is supplied in the motion and in the documents before you. No name of any proxy is supplied in the motion or in any of the documents before you. The name of the alleged circle is not identified. You can imagine, Mr. Speaker, sir, distinguished senators, being called to defend yourself on a claim that you have taken over through your associates a circle that we don't know. Told, now come and defend yourself. I began by saying some of these claims are either ridiculous or embarrassing. Secondly, at paragraph 74A, you'll be told that His Excellency has connived with cartels in the tea sector to block the Kenya Tea Development Agency from implementing guaranteed minimum returns that would benefit tea farmers. No statement, no affidavit, no correspondence from any official of the Kenya Tea Development Agency is before you. No complaint to any agency, no complaint to this parliament by any official of the Kenya Tea Development Agency is before you. It's just a claim which the mover of this motion said before the National Assembly, and surprisingly, to those of us who have some residual faith in our institution, he told the National Assembly, just believe my word for what it is. And when we thought that was a joke, we got a joke lifted a notch higher. The National Assembly actually just believed his word for what it is. No evidence. Nothing in the affidavits before you addresses anything about the Kenya Tea Development Agency. Nothing in the 5 affidavits before you. Let's progress, good people. Paragraph 72 of the motion before you states that His Excellency has persistently undermined, demeaned, and committed insubordination instead of assisting the President. And let's face it, Mr. Speaker, sir, distinguished senators, if you accuse somebody of insubordination, the only person who can complain of being insubordinated is the supervisor. No statement from the President, no affidavit from the President, even no witness summons to the President has been sought here to call him to complain he has been insubordinated. The Deputy President, when he received this motion, wrote to the Secretary to the Cabinet requesting to be supplied by all assignments given to him by the President and any that he has not delivered. To date, as we stand here, we have not received a response to that letter. And yet we shall be told, just believe the mover of this motion the Member of Parliament for Kibwezi West constituency, that when he is oscillating between the National Assembly and Kibwezi West to serve his people, he knows better than the supervisor of the Deputy President that the Deputy President has insubordinated his boss. I began by observing they will move from the false through the ridiculous to the embarrassing, and these are the claims before you. At paragraph 64, paragraph A of the impeachment motion, you will be told that His Excellency the Deputy President said that he would present a petition for the removal of Justice Esther Maina from office, which he has not done to date. Mr. Speaker, sir, my eyes are normally problematic, so I will not know the time allocation.
15 minutes.
Thank you so much, Mr. Speaker, sir. The claim is that His Excellency publicly said that he would present a petition for the removal of Justice Esther Maina from office, which he has not done to date. That's the complaint. Evidence is before you that there is a pending complaint by His Excellency, the Deputy President, before the Judicial Service Commission. So the mover of this motion first has perjured himself in his affidavit by saying that each of these facts are correct, when this fact is false by evidence available. You will find that paragraph 34 of the motion before you, it says that His Excellency falsely threatened to file a petition for removal of Justice Esther Maina. How can the Deputy President be accused of falsely threatening when in fact he has filed the complaint? Where is the falsehood when there is a pending complaint? That complaint is before you in the Deputy President's documents for your own perusal. I began by saying they'll move from the false through the ridiculous to the embarrassing. At paragraph 78C, you'll be told that His Excellency routinely summons procurement officers in ministries and state institutions and instructs them to direct procurement of goods and services in a specific manner. No officer from any ministry will swear an affidavit claiming to have been summoned to award any procurement for any goods or any services in a particular manner. In fact, what you'll have before you is actually very ridiculous. You will be told that there was a tender for supply of mosquito nets that was cancelled in May 2023. Then a local company that was an agent of the supplier was following for the return of its bid bond in July, 2 months after the cancellation of the tender. How can you influence a tender that was cancelled 2 months ago? I told you it will move from the false through the ridiculous to the embarrassing. Now, the more interesting one is at paragraph 78A. You will be told that His Excellency bullied Kenya Medical Supplies Agency officials into awarding a tender for the supply of mosquito nets to Crystal Limited. Good people, Crystal Limited was not even a bidder for that tender. He pressurized people to award it to somebody who is not even a bidder for that tender. I observed it will move from the false through the ridiculous to the embarrassing. Those of us who understand this motion for what it is, understand why these panel beating maneuvers are being tried here. The motion as presented and approved by the National Assembly will remain in our constitutional history as the most embarrassing motion ever approved by a House of Parliament in the Commonwealth. We respectfully submit. You'll be told at paragraph 58 that His Excellency is reasonably suspected to be the principal beneficiary of what are called dubious transactions by Lusona Events Limited. You will then go to the allegations on Lusona Events Limited and you want to see those transactions, how are they terminating to the Deputy President? You'll not come across any connection. They'll just say, a director of this company withdrew some money from his own company. The deputy president is a director. None of his family members are director. That person withdrew money from his company, bought a motor vehicle in his own name. The mover will say, I'm therefore drawing a reasonable conclusion that the deputy president is the beneficiary of this. Good people, the word reasonable has meaning known to law. I submit very respectfully that this falls short of the definition of the word reasonable suspicion. I submit it actually gravitates towards unreasonable suspicion. Now let's look at this. You'll be told that His Excellency has acquired 40 acres of land in Kakuret, Kamburaini in Nyeri. Evidence before you will show that this is land that the deputy president in fact bought from a current member of the National Assembly. So he knows that member. In 2015, before he even joined state office as a member of parliament, you are told that the purchase of this land in 2015 shows that in the last 2 years, the deputy president has amassed immense wealth. I began by saying, let's be elementarily decent. One of the most frustrating things about preparing for such a hopelessly conceptualized, hopelessly crafted, and hopelessly presented case is that you begin doubting yourself because you begin wondering, what am I not seeing? Land bought from a sitting member of the National Assembly in the year 2015 is supposed to be evidence that in the last 2 years, His Excellency Rigathi Gachagua has amassed immense wealth from the office of the president to acquire that property. Now, let's look at paragraph 45G. You'll be told that His Excellency has acquired 80 acres of land in Meru County. No land registration number is provided. Not even an affidavit of a neighbor who says, I know yes, this land is my neighbor. Just an allegation by the mover of this motion like that. And the Swahili say, ukistaajabu ya Musa utaona Firauni. This mover of this motion stood before the National Assembly and said, just believe me for this statement as it is. The first joke. The second joke, the National Assembly actually believed him and approved the motion. You'll be told that paragraph 45H, that His Excellency has acquired a dairy farm in Nyandarua County. Now, I guess we all have a common understanding of what a dairy farm is. His Excellency has no dairy farm in Nyandarua County. The move of this motion does not give us any evidence of this dairy farm in Nyandarua County. You'll be told that His Excellency has used the office of the Deputy President to corruptly influence unnecessary and expensive renovation of his official residence in Karen and Mombasa. What will shock you is this, good people. The contract for the renovation of the official residence of the Deputy President was signed by the controller of State House. Unless the move of this motion wants to make a claim that the Deputy President conspired with the State House to have this contract executed. Number two, it will be known to all of us as members of Parliament that the money for renovation of this official residence was approved by the National Assembly. Is the National Assembly conceding that it approved money for unnecessary expenditure by government? How can the National Assembly approve money for use for renovation of the residence of the Deputy President, then after that money is used for the intended purpose, the renovation of the official residence of the President, now drag the Deputy President for impeachment for the reason of that renovation? I said it will move through the ridiculous to the embarrassing. You'll be told that the Deputy President has a helicopter landing facility at his land, Ruguru, Kiamariga, 1223 in Madeira. The Deputy President simply has no helicopter landing pad on that farm, a small parcel of land with the napier grass, unless the mover of this motion can now convince us that new technology has emerged, that napier grass is the constructing material for landing pads for aircraft. That's the only way it can make sense. But because it doesn't make sense, good people, you'll agree with me, it moves from the false through the ridiculous to the embarrassing. Now let's deal with it. You'll be told the deputy president has amassed a wealth portfolio amounting to 5.2 billion shillings. Elementarily, we must then look at the particularization. Tell us which one is what, plus which one is what, plus which one is what, to amount to this 5.2 billion. This figure, the origin, is only known to the mover of this motion. There is nothing on the body of the motion. There is nothing in the documents attached to the motion. There is nothing in the video clips to be played by the mover of this motion that tells us mathematically how he arrived at this figure of 5.2 billion shillings. Then when the charges were read, distinguished senators, you had some 22 companies being read one by one. Thank you. 22 companies. A number of things will surprise you. You'll just find a company listed called Spiritway Limited. Nothing in this motion tells us what wrong has this company done. Nothing in the motion, completely. It just listed there the way it is. Fortis Vis Group Limited. Nothing in this motion tells us what wrong has Fortis Vis Group Limited done. They're just companies whose names have been listed, and we have spent the taxpayers' money this afternoon listening to these companies' names being written with nothing in this motion telling us. So what wrong has Dorcas Rigathi Foundation done? What act are you complaining of for that company? What omission are you complaining of in respect of that company? Heartland Supplies Limited, you just find a name of a company there. No wrongdoing is alluded to it. No allegation is made against it. They're just companies thrown there. Distinguished senators, the Romans called their assembly, which was the equivalent of this Senate, the patres. It was an advisory council. That name was derived from an old Latin word meaning father. Senate derives its name from the Latin word senex, meaning old man. All these words are supposed to address the sagacious, the state of wisdom of the Senate. If this Senate lives to its historical origin as the patres, if this Senate lives true to its Latin origins as the senex, the old man, the wise man, it will see through these lies, it will see through this ridiculousness, it will see through these embarrassing statements. If time were to permit, I will take you through other allegations that meet the same test of falsehood, ridiculousness, and embarrassment. Fortunately for us, the rules of procedure permit us to cross-examine the move of this motion and the respective witnesses as a way of bringing forth these lies much more clearly. We shall do that when the time presents itself. At the end of it all, we shall beseech you to do two things: to be true to your oath of office as senators, to be true to your oath of office as senators, to pour through this evidence, to listen keenly to this evidence, to make a decision premised on the evidence as tested here in cross-examination. And if you do that, we have no doubt in our mind, you will reach the same conclusion that what has been presented before you as a most consequential motion, perhaps in our lifetime, is false, is ridiculous, is embarrassing. I rest the governor's opening statement.
That is the Deputy President Council. It's not the governor.
My apologies, Mr. Speaker. I have been here multiple times on governance, and I think that is what was reigning in my mind. I raised the Deputy President's opening statement. My apologies for that.
Very well. Now, honorable senators will now move to hear the case of the National Assembly. Now, the National Assembly has 3 hours to present its case, meaning all the witnesses, evidence in chief, cross-examination will be given 2 hours. The legal team for the Deputy President, you'll have 2 hours to cross-examine the witnesses as presented by the National Assembly. Clerk, you may now usher in the first witness of the National Assembly.
Mr. Speaker, as we wait for the witness, I crave, if it finds favor with you, one of my assistants could come to help us with turning the pages. I reckon that way we would move much faster. He's got Boniface Mawira. He should be perhaps in the gallery.
That's a valid request. You may proceed. Counsel for the National Assembly, where are your witnesses coming from? They're taking too long.
I think they must be in room 4, Honorable Speaker. Our first witness is the Honorable Ekomas Mwingi Motuse, who was the mover of the motion.
Are you sure he's not deserted you?
It is always a risk in this type of business, Honorable Speaker, but I'm sure he's around.
So, Counsel, before you proceed, you first introduce yourself and the team.
Yes, for the record, Honorable Speaker, my name is Mudhomi Viankolu. I'll be doing the exam in chief on behalf of the National Assembly. I shall be assisted in that enterprise by my learned friend, Mr. Peter Manyonge Wanyama. I will cover grounds 1, 5, 6, and 7. And my learned friend will lead the witness in respect of the other grounds in the motion.
May the witness take the oath.
I, Mwengi Mutuse, do solemnly swear that the evidence that I shall give before the Senate in respect of the matters before the Senate shall be the truth, the whole truth, and nothing but the truth. So help me God.
Your 3 hours starts running from now.
So, good afternoon, sir. Again, just for the record, confirm your name and what you do for a living.
Mr. Speaker, Honorable Senators, my name is Mwengi Mutuse. I'm the Member of Parliament for Kibwezi West constituency, and I was the mover of the instant motion that is before your consideration in the National Assembly. I am also an advocate of the High Court of Kenya by profession.
So, great. Let's go straight to the motion due to the constraints of time. Honorable Speaker, the motion is in Volume 1 of the Assembly's bundle of documents. And allegation number 1 runs from pages 3 to 10 of Volume 1. So, without much ado, Honorable Mutuse, let's go to allegation number 1 of your impeachment motion. Can you tell the Senate in very condensed summary what is the grievance you have raised against His Excellency the Deputy President?
Honorable Speaker, Honorable Senators, on our ground 1 allegation against the Deputy President is that he has violated various articles of the Constitution that we have listed, being Article 10.2a, 10.2b, Article and C, Article 27, Article 73.1a, Article 732b, 75.1c, Article 129, as well as Article 147.1 as read together with Article 131.2c and b. And basically, what we are saying is that the Deputy President in the last 2 years has been in various places within the Republic of Kenya and has been publicizing a notion that Kenya is a company that is owned by shareholders, and only those who have shares in the company called Kenya, according to him, will benefit in terms of development and service delivery from the Republic. And it is our contention that Kenya is not a company. Kenya is a republic that is supposed to serve all Kenyans. And the particular articles of the Constitution that we have cited because of time also speak to the functions of the Deputy President being able to promote national unity and the country, citizens of Kenya being able to receive services and development from the government, including appointments, without discrimination. So that is in short.
Let's quickly go through some of those provisions. If you could be shown the preamble to our Constitution, what does the third paragraph say?
Mr. Speaker, Honorable Senators, the preamble to our Constitution, and I read the third paragraph, proud of our ethnic, cultural, and religious diversity. Underline ethnic, cultural, and religious diversity, and determined to live in peace and unity as one indivisible sovereign nation. One indivisible sovereign nation.
We'll come to the evidence you have adduced to support this shortly, but are the utterances you complain about consistent with that constitutional provision?
Definitely not at all.
Let's go quickly to Article 10. What does it say?
Article 10.1. The national values and principles of governance in this article bind all state organs, state officers, public officers, and all persons whenever any of them, A, applies or interprets this Constitution, B, enacts, applies or interprets any law, or C, makes or implements public policy decisions.
But, Honorable Member, someone would say these are just utterances and we surely can't remove a Deputy President from office because he has a loose tongue or something like that. What is the problem with these utterances in the context of our history as the Republic of Kenya?
Number one, the constitutional context is that they bind all state officers and the deputy president is a state officer. So there are no two ways. You cannot choose the laws to obey and which not to obey. But number two, we have also had an history in our country. All of us would remember that we had clashes in Likoni in 1992 where populations were displaced. We had problems in Molo, every other cycle of election cycle, 1992, 1997. Even most recently, the country almost torn apart during the post-election violence of 2007 and 2008. There are examples within the region. Rwanda, Burundi is still struggling. As we speak today, Congo is fighting. Across the globe, Yugoslavia, there has been problems, Bosnia, all these countries. And they all began from utterances of this nature.
So is it your testimony, therefore, that utterances of the type we're about to see are a threat to the very existence of Kenya as a republic?
Indeed, that is my testimony.
Is our lived history consistent with the submission that those are not utterances that should emanate from the Deputy President of the Republic?
Not just the Deputy President of the Republic, but not from any citizen of the Republic.
But Honorable Mutuse, have you placed any evidence? You say the Deputy President has been doing this for 2 years. Have you placed any material to prove this allegation?
Yes. We have placed videos, evidence in the form of videos that have been recorded in meetings where the Deputy President has been attending, being video 1, video 2, video 3, video 4, video 8, and video 11, which contain utterances of the Deputy President in that regard.
Mr. Speaker, I request we play video number 1 from the National Assembly set of videos.
Sisi lazima tungeangalia nyinyi. Hii serikali ni kampuni na ni ya shares. Si ndio? Ni ya shares. Kuna wenye kampuni, wale wako na shares mingi, kuna wale wako na chache, kuna wale hawana. Sasa nyinyi mliinvest kwa hii kampuni ya William Ruto na Rigathi Gachagua. Sasa lazima mvune. Yule ambaye alipanda atafanya nini? Simulipanda? Simuliamuka mapema? Mukasema hamutaki kusikia mambo ya ile system na nini? Muka-invest, mukapanda, mukapalilia, mukaweka mbolea, mukamwagilia maji, wakati ya kuvuna ndio huu. Na itakuwa namna hiyo. Najua wengine wananikashifu ati mimi nasema ati wale walipanda wavune kwanza. Iko makosa? Iko makosa? Hata hao watavuna lakini wangoje. Si wale walipanda ndio wavune kwanza. Wakishavuna wavune ile tabaki kidogo, wale wakupanda waingie watafute huko nini ile itapatikana wachukue wakwende. Si iko namna hiyo? Na itakuwa namna hiyo. Ndio watu wakipiga kura waelewe hii kura ni kusema nini. Hii kura iko na maana. Nyinyi hamwezi piga kelele huko, mpige kelele. Mnasema William Ruto ni bure, hawezi, mnaita yeye majina, alafu akipata akikawa mnapiga laini ati mko pale mbele. Ati mnataka mpite wale walisema anafaa ati mkue pale mbele. Inawezekana? Mimi kazi yangu pale kwa Ikulu ni hiyo. Ni kupanga hiyo laini. Hapo ni kazi mimi napanga hapo. Mimi naangalia kwa laini, nikiona wewe ulipanda, natoa wewe nyuma, napeleka wewe mbele.
Because of the constraint of time, Honorable Mutuse, what did these utterances mean and what were they understood by any fair-minded Kenyan to mean?
The ordinary meaning is that there are Kenyans who are supposed to benefit from the Kenyan government and there are other Kenyans who are not supposed to benefit from the Kenyan government. And His Excellency the Deputy President will make sure only those who voted for the present government benefit from the government. And those who did not vote for the government will not get any benefits because they are not shareholders.
Are those utterances consistent with the national value of human dignity in Article 10B?
Not at all.
Are they consistent with the value of national unity in Article 10A?
Not at all.
Are they consistent with social justice in Article 10(2)B?
Not at all.
What about inclusiveness?
Indeed, they are divisive.
What about equality?
Not at all.
What about non-discrimination?
They are very discriminative.
What about protection of the marginalized?
They do not protect the marginalized, they marginalize them further.
We could go on and on, sir. Are those utterances consistent with any of the articles you claim in ground 1 have been violated?
Not at all.
Let's play video number 2, Honorable Speaker.
President Rigathi Gachagua again brought up the political shareholding narrative, saying the Kenya Kwanza administration will prioritize Kenyans who voted for it in the distribution of government employment slots and development projects. Well, Gachagua spoke in Nandi County, where he led other government officials in a church service and thereafter a fundraiser at Kurgung Boys High School. Ayub Abdikadir reports.
Mosop constituency in Nandi County offered Gachagua a platform to amplify his narrative about the government being a shareholding entity that apparently belongs to those who voted for it, calling on the people of Nandi County to remain patient as the state works on development projects and employment opportunities that would prioritize Kenya Kwanza supporters.
Rais ako pale. Niko hapo. Huyu Felix ako hapo. Rais mnamjua. Mimi mnanijua msimamo yangu. Ya kwamba watoto wakiwa wengi kuna wale kwanza ya kuangaliwa, si mnajua? Sasa huyu Felix ako pale ndio mwenye kuunganisha mawaya. Mambo yetu tumepanga.
His remarks similar to the last time he sparked public debate by hinting at preferential treatment for Kenyans who voted for the government.
Mambo iko sawa. Chakula iko jikoni, karibu kuiva. Watoto ni wengi, chakula ni kidogo. Iko watoto ya nyumbani, iko ajirani, iko namna hiyo, na nyinyi mtulie. Chakula ikiiva, sisi ndio wenye kupakua. Na watoto tunawajua kwa sura na kwa msimamo. Hatuwezi kuwa confused. Kuna mtu wajua watoto yake.
The deputy president who led other Kenya Kwanza leaders for a church service and thereafter a fundraiser at Kurgung Boys High School also outlined measures.
Let's play. In the interest of time, Mr. Speaker, I want to play all of them, then I'll put the questions. Let's hear video number 3, I believe.
Gachagua says he has no apologies to make over his shareholders' narratives, saying those who voted in the Kenya Kwanza government should reap big from the government.
Well, Gachagua, who was speaking in Nandi County, where he led a fundraiser towards the construction of the ACK Plaza in Kapsabet town, also dismissed claims that there are differences between himself and President William Ruto. Martin Munene has the details.
Deputy President Rigathi Gachagua was in President William Ruto's Rift Valley backyard on Sunday, where he presided over a fundraiser in aid of Kapsabet ACK Church. And here the DP made it clear that he was not backing down on his shareholders' gospel that has left a bad taste in many people's mouths.
I am unapologetic to demand and to insist that those who believed in William Ruto and supported him to a man have every right to benefit immensely from his government. I have no apology.
Let's play video number 4, 8, and 11 in that sequence.
Serikali, a government is like a company. There is shareholding. Kuna wale who have invested a lot of shares. Kuna wale wameweka kidogo. Kuna wale wamekataa. Lakini wote ni wa Kenya. So ndio tukasema kama wewe umeenda kupanda mahindi, ama wacha nipeane example ya ng'ombe kwa sababu niko Kajiado. Wewe uko na ng'ombe yako ya maziwa. Hiyo ng'ombe imezaliwa ikiwa njao, umeichunga vizuri, umepatia majani, umenunulia dairy meal, umepatia chumvi, umepeleka kwa malisho, umepatia maji, imezaa, imeanza kukamuliwa. Wewe unatakiwa kwanza ukuwe mtu ya kwanza kukamua hiyo ng'ombe na kukunywa maziwa. Serikali, a government is like a company. There is shareholding. Kuna wale who have invested a lot of shares. Kuna wale wameweka kidogo. Kuna wale wamekataa. Lakini wote ni wa Kenya. So ndio tukasema kama wewe umeenda kupanda mahindi, ama wacha nipeane example ya ng'ombe kwa sababu niko Kajiado. Wewe uko na ng'ombe yako ya maziwa. Hiyo ng'ombe imezaliwa ikiwa njao.
We can go to the next because we see an element of repetition. Let's go to the next video.
Mimi nilisema pale Kericho watu ya Azimio wakanipigia kelele. Nikasema Kenya hii kila mtu afanyiwe kazi. Kwa sababu kila mtu analipa kodi. Na hao wabunge wakiongozwa na Kimani Ichung'wa wako pale bunge. Wagawe pesa kwa kila mtu Kenya. Na hivyo ndivyo inaendelea.
Yes, video number 11.
Fika watu ya kukusaidia. Utatafuta.
The good people of Homa Bay, that I am going to work with your leaders, the ones you have elected, so that we can develop our country together. Competition is over. Si tumemaliza mambo ya mashindano? Si tumemaliza mambo ya mashindano? Si ile kazi imebaki ni sisi kuwafanyia kazi sasa? Si ni kweli? Muko tayari kufanya kazi na mimi? Munasema nifanye kazi na viongozi wenu wale mliowachagua. Mimi nawahakikishia nitafanya kazi na wao, ndio tupange mambo ya maendeleo ya Homa Bay, tupange mambo ya maendeleo ya Kenya, ndio tuweze kupeleka taifa letu mbele. Tuondoe umaskini, tupange ajira ya hawa vijana, tupunguze gharama ya chakula, na tupange mambo ya maendeleo ya Kenya, tutengeneze nchi ambayo kila Mkenya anajivunia kuwa Mkenya.
So, Mutuse, you know, we could play these videos on and on. Unfortunately, time is not with us. But please confirm that you have presented before Senate utterances made by the Deputy President on this theme in Kitui. Is that correct?
That is correct.
In Nandi, is that correct?
That is correct.
In Kericho, is that correct?
That is correct.
In Kajiado?
That is correct.
Please confirm it is in public domain. These utterances have been made in very many other places. These were just illustrations.
Indeed, I suspect they have been made even in the counties represented by the senators seated here.
Have these been isolated aberrations, or has it been a consistent campaign and mantra by the Deputy President across the Republic?
It has been consistent, and as the Deputy President says, unapologetic.
But you also played for us a video where the President is speaking. How does it compare with the utterances and the campaign by his deputy?
The President is preaching national unity, and I believe that is a function assigned to the President under Article 131 of the Constitution, to be a symbol of national unity. And the Deputy President is also required to deputize the President in performance of his functions. And therefore, it will be expected that the Deputy President will take cue. Instead, the Deputy President is contradicting the President.
We have seen these events covered by a major television station, right?
Indeed.
Does that television, to the best of your knowledge, have national or is it local coverage?
National, and some of them regional coverage.
Should the Deputy President of the Republic have the wisdom to know his utterances will be conveyed to the country and the world?
Indeed, yes.
We saw him talking about children that belong to the family and although we don't use the language these days, some illegitimate children. Who was he calling children from outside the home, or the illegitimate ones?
Looking in totality for Moi's videos, he must have made those who voted for Kenya Kwanza as the legitimate children, and those who did not vote for Kenya Kwanza as the legitimate children.
We have seen him saying he has no apologies to make, notwithstanding that these utterances, to quote the media house, were leaving a bad taste in the mouths of many people. Is that correct or incorrect?
Yes, he is very loudly clear that he has no apologies to make for referring to Kenya, for saying Kenya is a company belonging to shareholders for the benefit of the shareholders.
That defiance and the stance that he has no apology to make, does it depict the deportment of a man or a woman who should be the Deputy President of the Republic of Kenya?
Not at all.
But you heard his counsel say that there must be some extraordinary wrongdoing before we can impeach for mere utterances or for the things you have alleged. To the best of your knowledge, sir, how many vice presidents or deputy presidents has Kenya had since 1963? In your estimate, how many?
11.
11.
11 or thereabout?
Let's say a dozen, 12, right?
Yes.
Do we have in our history since 1963 experience of a deputy president who traverses the country preaching ethnic exclusion?
I don't remember any. The only incident I remember, two incidences, when Jaramogi differed with Kenyatta and he did the moral thing, resigned from government. I also remember an incident, I think it was Vice President Murumbi, who also differed with the then president and did the honorable thing and resigned from government.
Those were the first two vice presidents. Daniel Arap Moi was at that. Do you know of any incident where Daniel Arap Moi was moving around this country as vice president, committing this type of wrongdoing?
No, not at all.
How about Mwai Kibaki?
In fact, even when he was demoted, he continued working in cabinet.
How about Josephat Karanja?
Not at all.
How about George Saitoti?
Even when he was sacked, he continued being loyal to the government of the day.
How about Musalia Mudavadi?
In his short stint, nothing is heard about him undermining his boss.
How about
dividing the country?
Mudi Awori?
Not at all.
Kalonzo Musyoka?
Not at all.
So when we are told there is nothing extraordinary about this wrongdoing, is that consistent with the lived reality of Kenya?
There is everything extraordinary when a country of 46 tribes, someone advocates for the servicing of less than 2 of those communities. Where will the 44 go?
Given the politics of 41 against 1 in 2007 and the post-election violence, would this allegation be extraordinary wrongdoing?
It is an extraordinary wrongdoing. In fact, the post-election violence that resulted from that particular kind of campaign was in itself extremely dangerous to our social fabric and extremely dangerous to our economy.
Given the experience of the Molo and Likoni clashes in the 90s, would this be extraordinary wrongdoing coming from the second senior-most state officer?
Indeed, and also when it is remembered that he was a district officer in Molo when those clashes were happening.
Given what is going on right now as we speak in Tana River, would conduct like this emanating from none other than the deputy of the president be extraordinary misconduct?
I have seen in news that there are families that are displaced, people have lost property, and if that is not extraordinary, then I do not know what extraordinary means.
Given, sir, and I will summarize this, what this type of campaign achieved in Rwanda, in Burundi, in Sudan, in South Sudan, in former Yugoslavia, in Nigeria, the Biafra War, and we could count and count until the cows go home. Can anyone be heard in good conscience to say that this is not extraordinary misconduct?
Indeed, this is very extraordinary, requiring impeachment.
Please confirm, because we are pressed for time, that the evidence you're relying on this ground applies equally to allegation number 5 of your motion.
Just a minute to confirm.
What is your complaint in allegation number 5? Allegation number 5, Mr. Speaker, will be at page 16 to 17 of volume 2.
Allegation number 5. Just a minute. Mr. Speaker, honorable members, our allegation number 5 relates to gross violation of Article 3(1) of the Constitution and Article 148(5)(a) of the Constitution, which specifically is in relation to the breach of the oath of office and allegiance.
Does the oath of office require the Deputy President to promote national unity or the shareholder politics?
The oath of office demands of the Deputy President to promote national unity.
And what is your complaint in ground number 6, sir?
In ground number 6,
that again is on page 16 to 17, Mr. Speaker.
Ground number 6 is about serious reasons to believe that the Deputy President has committed a crime under national law pursuant to Article 151(b) and 2 of the Constitution.
And what is the specific complaint?
The specific complaint is that there are serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 13(1)(a) and 62 of the National Cohesion and Integration Act.
Can you please read for us those sections of the law?
Section 13 of the National Cohesion and Integration Act provides that it is an offense.
Honorable Speaker, that section will be in volume 7 of the Assembly's documents.
That it is an offense for any person to use threatening, abusive, or insulting words or behavior where the person intends to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. The section also makes it an offense to use words or engage in such behavior when, having regard to all the circumstances, ethnic hatred is likely to be stirred up.
Is ethnic hatred likely to be stirred up by this campaign of shareholding?
Obviously.
Is it likely to stir up ethnic contempt?
Obviously.
What does Section 62 say?
Section 62 of the National Cohesion and Integration Act states that a person commits an offense when the person makes statements that are intended or are likely to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination.
Are the utterances by the Deputy President likely to trigger any of those things?
Yes, indeed.
As a matter of fact, Honorable Mutuse, that law you just read, National Cohesion and Integration, wasn't it the law Parliament enacted to ensure we never go back to where our country was in 2007, 2008 because of utterances like this?
It was pursuant to the post-election violence, and the country resolved that we needed a law as a result. And therefore, it is a law that is supposed to ensure that we in office live to promote national unity and not the opposite.
Given that history and why that law exists, sir, we repeat the question. Has the Deputy President committed ordinary or extraordinary wrongdoing?
He has, under Article 150 of the Constitution, in relation to this ground, the there are serious reasons to believe that he has committed wrongs against the National Cohesion and Integration Act, and if extraordinary in nature. And if you allow me, these are not my words. I have been accused of urging the National Assembly to believe me. These are not my words, they are words of the Constitution under Article 150.
Thank you. I want us, Mr. Speaker, we are urging the Senate, if you consider the evidence so far adduced, then that evidence applies to ground 1, 5, and 6. So we are prosecuting them together to save on time. Let's go to allegation number 7, sir. Mr. Speaker, that allegation runs from pages 17 to 31. It was the one you were told runs from falsehoods, culminating in the embarrassing and other things. Let's see whether it is actually falsehoods, embarrassing, and the other adjectives that we were told. And I would urge members to work with me by holding volume 2A of the Assembly's documents, together with our volume 6. 6, I only mention it briefly. Please confirm, sir, at page 2 of volume 6, who, as between you and the Deputy President, as passions were cast, that you're referring to irrelevant material about the estate of the late Rais Gachagua. Between you and the Deputy President, who has brought up this issue of the estate? Is it you or is it him?
In the response by the Deputy President, on page 2 of volume 6, he did bring out the issue of the estate of his late brother in response to the allegations that he has acquired properties worth 5.2 billion within the period that he has been Deputy President.
So we'll come back to that document much later. I'm only mentioning it now, sir, to clear the air, whether it is you trying to whip emotions by bringing up this matter, or it is the Deputy President attempting, by his own response, to hide behind the shadow of his late brother.
I never mentioned any of my deceased relatives. I have them, but I never mentioned any. The Deputy President is the one who mentioned his deceased relatives.
He's actually the one who has brought this material, isn't it?
Indeed.
Good. Now we'll come to it. Let's go back to your allegation. Ground number 7, sir. Can you tell the Senate in summary, we are so pressed for time, what is...
Mr. Speaker, honorable members, under ground number 7, our allegation is that there are serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 45(1), 46, 47(a)(3), and 48(1) of the Anti-Corruption Economic Crimes Act, as well as Sections 2, 3, 4, and 7 of the Proceeds of Crime and the Money Laundering Act. And in short, during the short period that I was doing research on this motion, I have come across properties that are registered in the name of the Deputy President or in the name of his children or other proxies that run cumulatively to a value of about 5.2 billion. And there is no clear trace of where the monies to purchase those properties came from, and therefore, under the Anti-Corruption and Economic Crimes Act, qualify to be unexplained assets. Number 2, I have also listed companies that are associated with the Deputy President, 22 of them. And these companies, you look at the objects and purposes, they are all the same. And it is our theory and our evidence that these companies have been used for money laundering. Similarly, I have also listed companies that have been transacting with the office of the Deputy President, the office held by the Deputy President, His Excellency Rigathi Gachagua, with tremendous respect. And they are being paid from that office, and we have laid ground for serious reasons to believe that these companies are actually conduits for corruption. and that political responsibility, even when he's not the accounting officer, rests with the highest holder of that office. And that is the case we are making here. And we shall be showing the connection between the properties and His Excellency Rigathi Gachagua. And in a case of unexplained assets, it is upon the person to show where they actually got the money to buy the assets. We have evidence that the assets belong to him.
Let's begin with the companies, Honorable Mutuse. You said you have attached Form CR12 to your motion.
Indeed, I have attached Form CR12 being evidence of ownership of those companies.
Would that be the Form CR12 on pages 8 all the way to 32 of Volume 2A?
Indeed, yes.
Honorable Speaker, it's Volume 2A, pages 8 to 32. It actually begins, Honorable Speaker, it's me who is mistaken. It's from page 1 to 32, right?
Indeed, yes.
And because we are stressed for time, sir, does this document show in black and white that the majority of these companies, the directors and shareholders, are either the deputy president or his sons or his spouse?
Yes, they do, and senators will have opportunity to look at the Form CR12s. Many of them are under 2 weeks old, so they are very recent.
Let's go to the question of the purchase
and
of...
You can also independently confirm from the e-citizen portal, it is only 650 shillings to do as a company search.
You have mentioned Treetops Hotel and Outspan Hotel in paragraph 45A.
Yes, indeed.
Let's confirm whether this is false, ridiculous, or embarrassing. Did the Deputy President issue a public address on the 7th of October in which he admitted acquiring these two hotels?
Yes, indeed, and it is part of our evidence.
So with that admission from him, can he be here to say your allegations are false, ridiculous, and embarrassing?
That is not expected from the son of Mau Mau.
Let's go to page 33, sir, of your volume 2A.
Mr. Speaker, sir, we have been patiently waiting and restraining myself from raising.
Pause the time for the National Assembly, please. Proceed, Council.
I've been constraining myself when listening to the proceedings, and Council is testifying instead of the witness testifying. Number two, he's asking leading questions in examination in chief, and Council understands the rules of examination.
A case in point, you're very general. A case in point?
The Hansons, Mr. Speaker, sir, will bear as witness, and the Senate is a custodian of the Hanson.
Council, I'm very alert. Any leading questions before you take your feet, I'll be able to object to it. I'm very alert to that. Proceed, Council.
Much obliged, Mr. Speaker. Let's go to page 33, sir. What is that document? On volume 2A?
On page 33, this is a discharge of charge between Wayne Holdings Limited and Aberdare Safari Lodges Limited.
Yes.
Drawn by the firm of Hamilton, Harris, and Matthews.
On page 34, what is given as the amount of the loan being discharged?
The loan being discharged is 143,885,042 shillings.
Please confirm this loan is being discharged as of 30th October 2023.
Yes, the loan is being discharged as at of 30th October 2023. And the loan was to Aberdare Safari Hotels Limited.
Would that mean this hotel was indebted before the Deputy President acquired it?
It was in evidence.
To what amount?
143,885,042 shillings.
Let's go to page 37. What is that document you have annexed, sir?
The document I've annexed here is that transfer instrument. Transfer to companies and limited liability partnerships.
Yes.
It is it's a document ordinarily that is used to transfer
interest in what?
Interest in property from one party to the next.
And who is acquiring that property according to this document?
The property, as at this time, belonged to Aberdare Safari Hotels Limited and is being transferred to Crystal Kenya Limited.
Is Crystal Kenya Limited a company linked to the Deputy President?
Yes, indeed, and we have annexed it's the Form CR12.
In which page?
The Form CR12 is on page 23 of our
Volume 2A.
Of our Volume 2A.
Who are given as the directors there?
The directors are one Keith Ikino Rigathi.
Who is that?
That is a son to Honorable Rigathi Gachagua.
Yes.
And the second director is Kevin Gachagua Rigathi.
Yes.
Also a son.
Now let's go back to 37. As the Deputy President in his response explained, where he got more than 500 million shillings, and to be precise, 535 million to acquire this hotel.
To begin with, the consideration for this transfer was Kenya shillings 535 million, and this needs to be added to the loan of 143 million.
Yes.
Cumulatively.
Yes.
So that you get the value, because the value of in terms of what was the purchase.
Yes.
In his response, and I have seen it, the Deputy President alludes that he got a loan of 600 million, that when he became Deputy President, he used to run this company called Crystal, but when he became Deputy President, he gave it to his children to run it. And he goes further to say that he got a loan of 600 million from the Credit Bank of Kenya.
Has he actually placed before this Senate evidence of the disbursement of any such loan?
I have seen a letter of offer for that loan, but I have not seen any evidence of disbursement nor any charge in respect of that loan.
Is a letter of offer a loan evidence that a loan has actually been given?
A letter of offer is just that, an offer.
That letter is annexed of offer, says that as security for the supposed loan, there will be directors' guarantees. Has he annexed those directors' guarantees?
To the best of my recollection, I have not seen them.
It says the loan will be secured by personal guarantees. Has he also annexed those personal guarantees?
I have not seen them.
Has he annexed any security known in the banking world for acquiring a loan of this amount?
What I have seen is, what I have seen in the letter of offer is at, I'm looking at it, is in terms of the lien and set-off at page 132 or 534, is that lien and set-off of a fixed deposit.
Please say which volume you're referring to on the page so that the Senate will walk with you.
The senators would wish to know where the letter of offer is contained. Which volume?
The letter of offer, Mr. Speaker.
Which page? What page?
It's in volume 6.
Is it volume 6, starting from page 98.
Yes, walk us through that letter of offer.
So there is a letter of offer, meaning there was an application for a loan. And this is to the directors of Crystal Kenya Limited. Crystal Kenya Limited is the company that is acquiring Aberdare Safari lodges. And the loan is in respect of an amount of 600 million. And in the clause for lien and set-off, I have seen that a lien and set-off or fixed deposits, this is on page 99, in respect of INO Crystal Kenya Limited for an aggregate amount of 300 million to be obtained, interest accrued shall be credited to your deposit settlement account.
Let's stick to that one for now. From elementary banking knowledge, what do we conclude from this issue of the 300 million?
My understanding is that the account held at the bank had 300 million shillings in cash, and that that amount was going to be part of the security for the loan.
So it means the Deputy President or his sons had already cash in that account of 300 million shillings?
Yes, which is also an asset that we are counting in accumulating the 5.2 billion.
Now let's count that 300 million, 535 million, and the 143 million that had been to be paid to pave way for this transaction.
Indeed, yes.
In estimate, that would be like how much money?
535 plus 300
is 835.
835 plus 143, roughly $1 billion shillings.
Roughly $1 billion shillings.
In respect of one transaction.
Just one property. Now, if the Deputy President were to save all his net salary for 10 years, would he be able to have savings of $1 billion shillings to acquire this hotel?
Not at all.
But because
from the legitimate source of income, which is his salary as Deputy President, as gazetted by the SRC, roughly around 1.2 billion after taxation, an aggregate of $1 million shillings, it would not be possible to acquire $1 billion shillings within a period of 2 years.
Now, these three figures, sir, whether it is the 143 million or the 300 million or the 535 million, as the Deputy President in his response offered any legitimate explanation of how he or his very young sons came upon this incredible fortune of money?
Nowhere in the response, other than the letter of offer that is in itself not evidence of acquiring a loan.
At page 39, who are shown as the parties to this transaction for Abadea's Hotel?
Page 39 of
volume 2A.
At page 39 of volume 2A, the parties to this transaction for Crystal Kenya Limited, Kevin Gachagua Rigathi and Keith Ikino Rigathi. For Abadea Safari Hotels, there is Robert Gadenji,
yes,
and Kenneth Waiboshi.
Are those two gentlemen you mentioned first related to the Deputy President?
Indeed, they are his children.
As a matter of fact, Honorable Mutusa, and will do it in the closing statement, does our Public Officer Ethics Act or the Leadership and Integrity Act, faced with facts like this, permit the Deputy President to hide behind his sons?
Not at all.
Is he allowed to hide behind any of his relatives?
Not at all.
What about his spouse?
Not at all.
So even if the Senate were to accept, for argument's sake, that this company is run by the sons and whatnot, would that, based on our Public Officer Ethics Act or the other act, which is the leadership, and would that be a valid answer to this unexplained wealth?
Section 35 of the Leadership and Integrity Act.
Please say the volume you're reading.
I'm reading from volume 7 in our bundle of documents at page 34. Acting through others. A state officer contravenes the code if the officer A causes anything to be done through another person that would constitute a contravention of the code if done by the state officer, or allows or directs a person under their supervision or control to do anything that is in contravention of the code.
Mr. Speaker, acting through others is what previously I have called it wasn't me. But let's jump to page 79 of volume 2A.
Yes, we are here.
Again, this is documentation for that same property the Deputy President admits he acquired, right?
Yes, through Aberdare, just for contextualization, Aberdare owned 2 hotels.
Yes.
There is Treetops Hotel.
Yes.
And there is...
There is which one?
Outspan.
Yes.
Outspan is the one that we have demonstrated how it was purchased. Treetops is a property developed by the Kenya Wildlife Service, but it was under the same management of Aberdare, so they were acquired together.
So let's pause at it is owned by the Kenya Wildlife Service.
Yes.
Is the Kenya Wildlife Service a public or a private entity?
A public entity funded by the taxpayers.
Under our Chapter 6 laws, that is the Public Officer Ethics Act, the Leadership and the Integrity Act, if you want, you can even draw the Public Procurement and Disposal Act, whichever law. Is it consistent with all those laws for the Deputy President of the Republic to acquire without competitive bidding an interest in a resource owned by the Kenya Wildlife Service?
It is not. And in fact, the Deputy President is on record in these proceedings as having said that he has advised his family not to transact with government. But we are going to demonstrate that he actually transacted with KWS.
And KWS is a public entity?
And KWS is a public entity.
If this hotel were to be leased or sold, or whatever the language, would there be a requirement for open, competitive, and transparent bidding?
Section 45, which we said we have reasonable grounds to believe that the Deputy President has breached of the Anti-Corruption and Economic Crimes Act. And I'm reading Volume 7 at page 23, states as follows. Protection of public property and revenue. A person is guilty of an offense if the person fraudulently or otherwise unlawfully A, acquires public property or public service or benefit, B, mortgages, charges, or disposes of any public property, C, damages public property including causing a computer or another electronic machinery to perform any function that directly or indirectly results in a loss or adversely affects any public revenue or service, or fails to pay any taxes or any fees, levies, charges payable to any public body, or effects or obtains an exemption, remission, reduction, or abatement from payment of any such taxes, levies, and fees. Section 46, about abuse of office. A person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense.
Now, let's go to page 81 of Volume 2A, sir. It's still about Treetops Hotel.
Page
81 of Volume 2A.
I'm there.
Can you read for us the last sentence of the second paragraph?
This is a letter. This is a letter from the Kenya Wildlife Service.
Yes.
To Mr. Amos Kisilo of Kisilo and Wandati Company Advocates.
It's a letter dated when?
The letter is dated
at the top left. What is the date?
5th of June, 2023.
Was His Excellency, the Honorable Rigathi Gachagua, the Deputy President of Kenya on that date?
Yes.
It is addressed to who?
It is addressed to Kisilo, Wandati and Company Advocates.
In the Deputy President's own response, is that law firm indicated as one of the law firms he uses?
Yes, indeed.
Good. Now read for us the second paragraph of that letter, beginning with the word however.
However, the tenant is in rent arrears of Kenya shillings 35,481,548, and lodge has not been operational since 2019, which has resulted to deterioration of the same in breach of the lease agreement.
So we are being told this hotel a number of things. One, it has not been in operation for 4 years, correct?
Indeed.
And as a result, it has accumulated rent arrears. Correct or incorrect?
And deteriorated, which in effect means it requires renovation money.
Now let's go to page 80 where the Deputy President develops interest in the hotel.
I'm here.
Can you read the opening line of that, the first paragraph of that letter?
Mr. Speaker, honorable senators, this is a letter from Kisilo Andati and Company Advocates to the Director General of the Kenya Wildlife Service. The opening sentence reads as follows. We act for a party, into brackets our client, who is interested in taking on an assignment of lease of the Treetops Hotel Lodge as defined in the lease agreement dated 31st December 1998 between yourselves and Aberdare Safari Lodges Limited, the lessee.
Please confirm this is a letter by the Deputy President's lawyers.
This indeed is a letter by the Deputy President lawyers, but funny enough, against any all professional knowledge in terms of how you write letters, they do not disclose their client. They just say,
we act for a party. Who is our, does that letter disclose the identity of the client anywhere?
No, it doesn't. And it is a requirement that you must disclose the client even as you move ahead.
Is that how lawyers usually write letters in honest, genuine transactions?
Not at all.
Good. Now let's go.
And I am one of them, so I know.
Let's go to page 83 of volume 2A. What is written there?
Page 83 is a letter to Dr. Kanga, Director General Acting, Kenya Wildlife Service from Aberdare Safari Hotels.
So,
it is about Treetops Lodge debt and lease.
Please hold 83 together with 81. In 81, we are told the hotel has not been in operation for 4 years, and that's why it's in rent arrears, right?
Yes, rent arrears of upwards of 35 million.
And that is on which date?
This is on 5th of June 2023.
And the letter at page 83 is on what date?
It's 7th of July 2023, a month later.
How many days in between, roughly?
Roughly a month, 30 days or so.
Roughly a month. And what does this letter say?
The letter says, I refer to Treetops rent arrears debt of Kenya shillings 35,481,548.14, and I am pleased to inform you that the Aberdare Safari Hotels Limited has today paid via RTGS bank transfer amount of 34,869,797 to KWS main collection standard chartered bank account, and the amount of 611 to KRA for 2% withholding tax.
So, Honorable Mutuse, what do you have to tell the Senate of the fact a company that was in arrears for 4 years, 35 million, it is in distress, it's not in operation, the Deputy President shows interest, and suddenly it is able to pay these arrears of that 5 million?
The Deputy President must be magical. Associating with the Deputy President must be very magical, because you have not operated for over 4 years, you are in debt, you have not been able to service that debt for 4 years, but you have just interacted with him for a month, and you pay your debt overnight.
Now, when you see that, sir, is it consistent with the narrative that your allegations are false, ridiculous, and embarrassing?
Not at all. Indeed, our allegations are backed up by cogent evidence, as we have demonstrated.
What is the document at page 85 of volume 2A?
At page 85, this is a letter by Kenya Wildlife Service to one Ken Waiboshi, who is the Managing Director of Aberdare Safari Lodges, and it is acknowledgement of funds.
How much money?
We acknowledge, the letter reads as follows in paragraph 2, we acknowledge receipt of Kenya shillings 34,481.
As the Deputy President in his response explained the mysterious availability of these 35 million shillings when he comes to the picture?
I have not seen anywhere where it explains where this money came from.
Page 87, what is that document?
At page 87.
Or volume 2A, Mr. Speaker.
This is novation and assignment of lease agreement and addendum to lease dated 31st December 1998 and 27th July 2023, respectively, between Kenya Wildlife Service, Aberdare Safari Lodges Limited, and Crystal Kenya Limited, the company of interest.
Does this confirm, just like the deputy admitted, that he actually acquired Treetops Hotel?
Indeed, it confirms, and it is not. It has not been contested.
Is your allegation, therefore, Mr. Mutuse, about Treetops, false, ridiculous, and embarrassing?
Come again?
The evidence you just taken the Senate through about Treetops Hotel, is it consistent with the narrative of a move of motion who makes ridiculous, false, and embarrassing claims?
Not at all. It demonstrates that our allegations are not malicious. They are backed.
Let's go to his response in volume 6. It should be page 8, if I'm not mistaken, Mr. Speaker. Eight of volume 6.
Yes, there we are. Volume 6. On page.
Okay. Is page 9?
Yes.
At the top of page 9, what does the Deputy President in his response to the National Assembly tell it?
He says, in respect to Crystal Kenya Limited, this company was incorporated in 2009, way before I became Deputy President.
Let's pause there. Is that a valid response to your motion, the date when the company was incorporated?
I am interested in what the company did when Mr. Rigathi Gachagua is Deputy President, and not when the company was incorporated.
Okay, read for us the next line.
I transferred the company to my sons when I became Deputy President.
Is that a valid answer given the things we've just seen about Treetops and Outspan?
It confirms that the sons indeed are acting on his behalf.
Read the next line, please.
It acquired Outspan